Slips, my lord, item number 31. Actually, it is listed at my instant, my lord, but somehow I have come from my client that certain development is going on. So I would like to file one additional affidavit, my lord. So some 1 week time may be granted.
In the prayer of
31.
Mrs. K. Devi, learned counsel for the petitioner, this matter stands adjourned for a week so as to enable her to file an additional affidavit, bringing on record certain subsequent developments. List the matter accordingly.
Highly obliged.
A fervent prayer for listing, Milord. One 2016 matters hearing stage. Some urgencies there, Milord.
You give a list, we are taking up old matters. It's
But
listed every
raise
day.
the stage, Milord, to make a mention because its hearing was not fixed. One matter for listing on 27/6 if not inconvenient.
No, but why suddenly 27/6?
Milord,
So-
we
so
have
no,
just made, we have
You
just
wait, you could wait for 7 years and then now you want to call.
right. Lordship is correct. I just make a mention of a date, Milord. It is according to your
These are
lordship.
all matters which will be listed after the summer vacation. So you put a date after summer
My
vacation.
And one matter for this is 2023 matter. We need we are praying for an interim. My lord, otherwise the matter may be infructuous. Can it be on Monday next month?
Motion,
Yes.
motion
No, not
matter.
motion. Sorry, admission.
Admission, what interim? You didn't get an interim order in
The
motion.
interim order was such that the subject to the outcome of the petition, but some new development has taken.
Get it whenever you want, but that is the order. That cannot be changed now.
May I try my luck once?
You know how things happen.
And I understand.
Without an IA, question of passing a further interim order does not arise. Have it tomorrow on Monday,
Monday,
but that is the order will be passed.
Monday may I try. God bless you.
You can't get an interim order at admission stage when the motion order was that subject to outcome. You know how it is. You know how the system performs. Why are you unnecessarily burdening the system? If you have a subsequent development, you have to file an IE. Otherwise, on the same facts, now another court will pass another order. Is it possible? The learned single judge has not given you the interim order. So either you appeal, or if there is a subsequent development, you file an IE. You want the same order now to be modified in the admission stage. I don't think these are reasonable requests, but you have it. Everybody wants every matter to be listed tomorrow or day after tomorrow without, if you don't use your discretion, then a time will come when judges will stop using their discretion. Be aware of that. Yes.
May I please, as a lordship? My lord, I beg to mention item number 3 of today's list, my lord.
Hmm.
My lord, this matter has become infructuous, my lord. We have received the instruction, my lord.
Item 3, you write, Mr. Ayar, we and I counsel for the petitioner submits that he has received instructions from his client, which goes to show that the writ petition has become infructuous.
My-
Taking note of the submission of Mr. Bhuya, this writ petition stands closed as infructuous. Is there any interim order?
No, my lord. Obliged, my lord.
May I please your lordship? My lord, first writ petition filed on 14/6. Lordships may I pay for listing on 19/6.
It will be on 21st.
21st.
Lordship, I beg to mention one IA for correction of order, Lordship.
21st.
May it please, lordship. My lord, I beg to mention one contempt case, my lord. Orders, my lord.
After vacation, yes.
May I please, lordship? I would like to mention item number 55, lordship. 55, it is listed today for the first time, but it is listed under order column. So it may be taken up along with the motion matter.
No, you wait. When the matter reaches, we'll issue notice in this case. Yes. Yes.
May I have your lordship? Lordship, I am praying for listing matter for admission, lordship. And the
After vacation.
May it please, my lord, with a consent to the other side, I beg to mention item 37. While on this matter, on behalf of APDCL, we need some time to file affidavit, my lord, to obtain instructions in this matter.
You have informed the other side.
Yes, my lord, we'll take it to consent.
Mr.
A. Borwa.
A. Borwa, learned counsel appearing for the APDCL 6 adjournment in this case on the ground that he needs to file affidavit.
Affidavit.
Since the prayer is made with the consent of the petitioner's counsel, same stands alone. Let this matter be listed again after the summer vacation. Affidavit on behalf of the respondents be brought on record, comma, in the meantime, comma, by serving advance copy upon the petitioner's counsel.
I'm obliged.
Lordship, I will be allowed to withdraw, my lord, subsequent to the condition, the appropriate application be filed if time lordship is necessary.
Ms. B. Bhuya, learned counsel for the applicant seeks leave of this court to withdraw this application with liberty to file afresh after making necessary. Why you want to withdraw?
Because they have complied with the order, but area payment has not been made to me, area pension.
Seeks leave of this court to withdraw this application. But then you want to withdraw the contempt case.
Yes, because once they have complied with the order.
If the contempt case is. Ms. B. Bhuya, learned counsel for the petitioner submits that the respondents have complied with the court order. However, the petitioner is yet to receive the
Area outstanding payment
Area
of
outstanding
pension
payments.
amount.
area outstanding pension amount. Therefore, seeking, therefore, the petitioner wants to withdraw this contempt case by reserving her right to move the court again
My lord.
as and when appropriate occasion arises. Prayer allowed, contempt case stands closed. But in view of the order, so and so IS stands disposed of.
May it please your lordship, I want to withdraw the petition.
Yes, Miss M. Gogoi, learned counsel for the petitioner submits that with instructions from her client to withdraw this petition. The prayer is not opposed by Miss B.
Arbora,
Arbora,
Agriculture
learned standing counsel, Agriculture Department. In view of the above, this petition stands disposed of on withdrawal.
Obliged, my lord.
May it please your lordship. I will just do non-promotion, non-grant of promotion to the petitioners from labor inspector to labor officer, lordship. In the meantime, lordship, the petitioners all have retired, lordship, and I have contact with only one of the petitioner, the other two I don't have contact. Otherwise, lordship, this
Now
petitioner,
this prayer cannot be granted. How can you get promotion now?
notional benefit in the lordship.
Notional benefit, how is, if the promotion order was passed while in service,
Lord,
then notional benefit can be given. But now there cannot be consideration.
but
for promotion.
lordship, promotion was rejected illegally, lordship.
Hmm.
So if lordship finds that there is merit in the case, then lordship may grant the notional benefit, lordship.
No. What is illegal? Why illegally it was rejected?
Yes, lordship, that the impugn order is annexure B.
Who is appearing for the state?
Page 15, lordship.
Hmm.
Lordship, here says, lordship, initially the petitioners were appointed as LDA, that is ministerial cadre.
Hmm.
Lordship, in the labor and employment department of government. Then subsequently they were promoted, lordship, to the post of labor inspector. Then lordship, after serving in the post of labor inspector for 13 to 14 years, lordship, they were a merit list was prepared, not merit list, a seniority list was prepared, lordship, wherein the petitioners were names were also reflected. Thereafter, they represented the authorities to lordship, give them the grant them the promotional benefit to the next post of labor officer, lordship. But authorities they did not give. Then they finally give this reply at page 15, lordship, asking them to appear for the departmental examination. Whereas, lordship, the departmental examination is required for the confirmation of the post, lordship. And the petitioners were confirmed initially, lordship. The confirmed order I have not annexed with the petition, lordship. It is with me, lordship. When they were in the ministerial cadre, they have been their post will be. This is the order of confirmation, lordship.
Where is Assam Labor Service Rules 1970?
Not. So in the page 15, they are saying, may I read the in the page 15, that's it. The two order confirmation of the orders of the two petitioners. Lordship.
Confirmation in which post?
Confirmation as the lordship, a law division assistant. Lordship. The following temporary division of the assistance office I have a confirmed in the post of law division, lordship.
No. Where is the order of confirmation as labor inspector?
No, labor inspector. They were initially confirmed. After lordship absorbing, they were confirmed as labor. They were promoted, lordship, to labor inspector. In the department, they were confirmed. Then the lordship, as per the lordship, that impugn order at page 15, it says that lordship. May I read the lordship?
Yes.
Page 15, lordship. Passing of the subject, passing of departmental examination. I am to say that the officer in the cadre of labor officers and labor inspectors as per the list enclosed have not yet passed departmental examination as required under Rule 12 and 14 of the Assam Labor Service Rule 1970. In some cases, after completion of more than 14 years of service. It may be noted that as per aforesaid rules, every member in the labor service is, amongst other conditions, required to pass the departmental examination for confirmation. It is for confirmation in the cadre post. And Lordship, for a rule, they are here showing Lordship, Rule 12 and 14. That should be followed. And Rule 12, 12 says about the probation, Lordship, and 14 says about confirmation. Rule 12, Lordship. It speaks about probation, those who are not confirmed, Lordship. And Rule 40 speaks about Lordship confirmation.
Now, how can the relief be granted to you today? Any authority? How
Lordship.
can you get promotion today? Against which vacancy?
That is not, therefore, Lordship, I am praying for the notional benefit, Lordship.
Notional benefit is once you get the promotion.
Lordship is correct.
Promotion is not guaranteed.
Yes,
Only
Lordship.
consideration is guaranteed.
Yes, Lordship is correct, Lordship.
What do you have to say?
My lord, the thing is that we have filed an affidavit. My lord, they did not sit for the department, they could not clear the departmental examination. That is why, my lord, it's in paragraph 9 of our affidavit in opposition, my lord.
Hmm.
It starts from 8. My lord, there is two era, 1985 prior and post. Post 1985, they have to clear a departmental examination for the promotion. They did not clear. That is why we did not give them promotion. That is what my affidavit says, madam.
Yes, but he's given copies of the
Confirmation. Lordship.
notification by means of which they were confirmed in the
Lordship.
post of law divisional assistant.
Lordship. And Lordship, in the reply, we have filed reply also, Lordship, to the affidavit, Lordship.
Why have you not annexed it in the writ petition?
At that time, Lordship, initially I didn't have that, subsequently I obtained, Lordship. I only-
Submit a representation before the authorities to consider your.
Yes,
grievance.
they will, Lordship, that may be.
Heard Mr. A. Tarvildar Learned Counsel for the writ petitioner. Also heard Mr. R. Dhar Learned Additional Senior Government Advocate Assam appearing for the respondents. First up, the three writ petitioners herein were initially appointed as lower division assistant in the office of the Labor Commissioner, Assam. First up, subsequently, they were promoted to the post of Labor Inspector.
Lordship.
First up, according to the petitioners, after serving in the post of, after serving for more than 13-14 years, they were entitled to be considered for promotion to the next higher rank of labor officer.
Lordship.
First up, however, their candidatures were not considered by the authorities on the ground that the petitioners had not
Qualified.
passed the,
Not passed.
had not passed the
Departmental examination. Page 15, Lordship.
departmental examination as required under rules 12 and 14 of the Assam Labor Service Rules, 1970, which fact was communicated by letter dated 15/12/1999. First up, by referring to rules 12 and 14, Mr. Tarvildar submits that the said rule applies in case of a probationer at the stage of initial entry in service. First up, however, the writ petitioners have had all been confirmed in the post of LDA. As such, rules 12 and 13 of 12 and 14 of the rules of 1970 did not have any application in this case. Notwithstanding the same, the request made by the petitioners for consideration of their candidature for promotion to the post of labor officer had been wrongly rejected by the authorities. Full stop. In support of his above argument, Mr. Tahvildar has produced copies of the notifications dated 27/12/1983 and 30/12/1983 pertaining to the petitioner numbers
Petitioner number Lordship. 3 and Lordship 1.
1 and 3
Lordship.
to submit that both these petitioners had been confirmed as LDA.
Lordship.
Full stop. However, these notifications are not a part of the record. Full stop. Be that as it may, from a plain reading of the provisions of rules 12 and 14 of the rules of 70, it appears that that rule 12 is applicable in case of probationers whose services are yet to be confirmed. Full stop. Likewise, Rule 14 applies in case of probationers who are required to pass the departmental examination for their confirmation. Full stop. If that be so, I find force in the submission of Mr. Tahvildar that having been confirmed in the post of LDA, the petitioner numbers 1 and 3 were not required to appear again in the departmental examination. First up, however, there is no material before this court to draw a similar conclusion with regard to the petitioner number 2. Be that as it may, since all the petitioners have already retired from service on attaining the age of superannuation, and considering the nature of grievance expressed by them, more particularly the relief prayed by the petitioners for giving them notional benefit in terms of pay stroke pension in the post of labor officer. This writ petition is disposed of by granting liberty to the petitioners to submit appropriate representation before the Commissioner and Secretary to the Government of Assam Labour Department by enclosing a copy of this order. If such representation is submitted by annexing supporting documents, then in that event, the grievance of the petitioners be looked into in the light of the provisions of rules of 1970, and thereafter a speaking order be passed addressing the issues. Post up. With the above observation, the writ petition stands disposed of. What is this IA? There is IA.
No, Lordship. Obliged, Lordship.
My lord, this matter has been admitted on 23rd of March 2018. Thereafter, my lord. In this case, we have filed the they have filed their affidavit, we have filed our reply also. And otherwise, this matter is ready, my lord.
What is the matter about?
My lord, the petitioner who has been impeded for a temporary appointment as sweeper in the State Bank of India, page number 16, my lord, can you have a look at, my lord? Page 15 first, my lord, can you see? A short matter otherwise. My lord, 9/1/2004, impediment for a temporary appointment of general attendant. It has been decided to hold an interview in connection with preparation of a panel list for temporary appointment of general attendant 22/1/2004. As your name has been sponsored by the District Employment Exchange for the purpose, you are requested to appear along with following documents. Now, kindly, my lord, next page, my lord. Page number 16. This is staff subordinate preparation of panel for temporary appointment of general attendant, sweeper, district usher. With reference to the above, we have to advise that an interview for preparation of a panel list for temporary appointment of general attendant at the branches of Kachar district was held on 22/1/04 at the office. The list of successful candidates in order of merit along with their permanent address are furnished. Now, kindly see, my lord, number 1 and 2. This number 2 is the petitioner before your lordships today, my lord. Now, my lord, next page, kindly, that paragraph 2. Please, therefore, arrange to make necessary arrangement for replacing existing temporary general attendant, if any, presently working at your branch,
from the above panel list and also not to utilize the service on purely temporary basis whenever necessity arises in future, such as leave, death, retirement, etc. A new panel will be forced with such and such. So far I'm concerned, I have been appointed in the death vacancy, my lord. It is there in that. My lord, now lordship may kindly come to the page number 20, my lord.
Page number?
20. That's my appointment letter.
Yes.
As per regional office panel list for temporary appointment, you are hereby temporarily appointed as general attendant at this branch with effect from 15/6/2004. So please come to page number 23, my lord. Page number 23, the next relevant page is, my lord. This is by the branch manager to the assistant general manager, SBI, Silchar. Miscellaneous Sri Premlal Balmiki deceased. We have to advise that Sri Premlal Balmiki sweeper expired on 2/12/2003. Since then, the sweeping work of the branch premises was done by engaging a daily labor till 14/6/04. Because no permanent sweeper was posted, the work is being done by one Sri Paplunath, this petitioner, who have reportedly been engaged from this panel, from the panel of sweepers maintained at regional office, a temporary capacity. In this connection, we would like to advise that salaries and allowances of Sri Paplunath is being paid through the establishment branch register with a break of 1 day in each block of 90 days period. Incidentally, the Nath is found to be sincere in his duties and obedient too. We shall therefore request regional office to make arrangement for his absorption permanently as sweeper of the branch. Now, please come to page 24, my lord. Next page, my lord. My lord, this is again by the assistant general manager. My lord, in this context, we have been advised by our general office Guwahati that they have already taken up the matter with the authority for sanction of the post, my lord. Now, kindly see page 25, my lord. Not much page. Page 25. This is by the branch manager to the assistant manager. In terms of telephone instruction dated 11th instant, LO Guwahati advising us to create PF number of Sri Paplunath, temporarily attendant with the PGB department to enable them to pay the salary from the month of April 09 through this site. We therefore be glad if you kindly arrange the create PF number Paplunath. We have taken up the assistant manager such for payment of salary of temporary attendant. Right number such, my lord. Now come to page number 20, my lord, 26. That number has been given. A Paplunath PF index number they have given. Now, my lord, please come to page number 27. That is also relevant paper, my lord. Dated 7th of May 2020 to the assistant manager by the branch manager. With reference to the above, we beg to advise that Sri Paplunath has been appointed on a purely temporary basis as a general attendant sweeper full time on 15/6/04. On the demise of permanent sweeper Sri Premlal Balmiki, who died on 2/12/03. From the panel list of appointment of general attendant for the district of Kachar, which was prepared at the regional office, Silchar, and the same has been circulated to the branch on 26/02/04. We are since utilizing the services of purely temporary basis, full-time sweeper. His salary allowances are being paid by debt to charges such and such, my lord. And the salary portion, my lord, basic, DA, HRA, all these things, 6,277. We shall therefore be glad to receive your kind instruction to pay the wages, salary of temporary attendant from such and such. Now, page number 28, my lord. This is by again this branch manager, assistant general manager to the chief manager.
So, Mr. Nath, what is your case? What is the
My
matter?
case is now, I have been impaneled, they're saying temporarily, in 2004. I was appointed in that particular post in 2004. I was and the post.
No, these are the particulars of your case.
Yes.
What is your
my
case?
my case is, my lord. My prayer is, my lord, since I am working in that permanent vacancy of Balmiki who deceased, he's a permanent employee, my lord. That's my one of the prayer, my lord.
Case I'm asking.
My lord, kindly just have a look at another thing. Please come to page number 26. There is serial number 1 is one Shivendu Kumar Nath.
Yes,
page
your
60.
case is that your service should be regularized and your salary should be paid.
My service.
That is your case.
That's my lord.
Other things we are saying is not your case.
No,
These are particulars of your case.
because of that, I have shown the documents, my lord. Because 10 years now is a 20 years I am working in the permanent post, my lord. 2004 since it's now 23 now, my lord. I'm working there, and they have implemented the list, my lord.
Yes,
Post is also
who's
sanctioned, my lord. And my lord, only one thing, my lord. Just one thing, one bit. Serial number 1, page 16, my lord. Kindly just have a look once. Yes.
Page
16, 16. Kindly just have a look, only one point, my lord. This document, kindly. Page 16, lordship has seen serial number 1, MPNL candidate Shibendu Kumar, Lordship has seen, my lord,
Hmm,
page 16.
yes.
Kindly see this document just now I have given, my lord. This person, he has been selected along with me and he has been regularized. This is the document. Kindly look at his, my lord, salary also. He's getting 26,000.
Yes, who is appearing for the bank?
My lord,
We have appointed someone in 2004 against a permanent vacancy.
Not permanent vacancy.
No, the sweeper who was permanent sweeper, he died in that vacancy.
No, my lord. As per my instruction,
Hmm,
the appointment was on the purely temporary basis.
correct. That's why the regularization.
That is there.
Hmm.
But lordship, what happened? He
How
was-
long can you keep an employee temporary?
Lordship, that is one of the crux. But one question is there, Lordship, he was earlier a canteen boy. He has been then posted as general attendant sweeper. Then on the date of Premlal Balmiki, he was again posted against his vacancy. That was also temporary. He was not given otherwise that regular salary that way.
That is why he is here before the court.
That is the thing, Lordship, and his recommendation. The petitioner has harped on his recommendation of various branch offices. No doubt, his jobs may be or services may be satisfactory for some officers, but the post is admittedly not sanctioned. There is no
So
sanction.
what do you want to do? You don't want to regularize him.
Lordship,
You don't want to regularize him.
Lordship, that is not the question. It is Lordship, what is that? That I would like to harp on, Lordship.
Why does the authorities across the board have allergy towards regularization? They want to keep people in the grade 4 level in temporary service forever.
That is.
The reason
that
is,
there, that he
If
has
you
a
don't
long
listen to
service
me, I
record.
terminate you. That
So-
is the reason.
So that is their Lordship.
But that is not a constitutional reason.
That is their Lordship. But one more thing I would like to just
Nobody wants to confirm the services of grade 4 category employees.
that is their
Because
Lordship.
if they confirm, then they will not dance to the tune of their masters.
Lordship.
That's the feeling. But that's
Lordship,
not constitutionally
I-
correct.
After E-Lordship, a point of 1996 11 Supreme Court
Hmm.
cases 341. In this case, Lordship, it was held that it is seen that the pursuant to the inquiry whether the temporary status should be granted to part-time employees. Directions were
Is
issued.
the petitioner a part-time employee? Is he a
Lordship.
part-time employee?
It was on daily basis, Lordship, earlier.
No, but the document shows that he was paid a salary scale.
subsequently in 2007, they sent me, my lord, for that daily wage on, they've sent me.
You see page
Lordship,
27, there is a,
Lordship, may I kindly turn to my affidavit, page 2, para 6.
yes,
Lordship, certain things are, those are what are correct, Lordship, that is there, but it is pertinent to state here that the interview held for the temporary appointment for general attendance sweeper has no nexus with the petitioner's previous engagement canteen boy. He was earlier a canteen boy, then he worked as the canteen boy from 1999 September to 2002 September, Lordship. Thereafter, again, his appointment was.
No, Mr. Talukdar,
Lordship.
what this we have understood. You see, there are certain things nobody questions because these are in the realm of administrative
Lordship.
discretion of the authorities. Who will be placed where, canteen or sweeper? If the court starts interfering on these things, then your authorities will have nothing to fall back on. But after lapse of 10, 15 years, if these arguments are made, where will these poor people go? They don't know the nitty-gritties of
Exactly,
law.
Lordship. I consent to the Lordship's.
2004 and this is 2023.
Yes,
19 years he has served. And now if you show him the rule book, where is he going to go? He has worked for 19 years. That's not in dispute.
of course, Lordship.
Then-
He has certainly, he has got certain reasonable expectation also to that effect in view of his
Correct.
span of, that is their Lordship. But the bank's instruction is that that is the position, legal position so far he is concerned. What I have submitted before your
Bank
Lordship
is
is that,
showing law to the grade 4 employees. Huh?
Lordship,
What is the law here? How are the people going to survive? And today, where will he go? Tomorrow, if you terminate his service because he's a temporary, where is he going to go? This is the problem with everyone. And if these stands go on happening, then the law will also change someday. In that case, the discretion of the authorities to even assign postings will be very difficult. We have seen what is happening in the state government jobs. Today, the discretion of the authorities to make an appointment is practically gone. Because they have made appointments, then subsequently not regularized, come up with legal arguments. Courts have dealt with those arguments and laid down the law. But there was a time when the officials had a lot of discretionary power. Now that is gone.
That is true, Lordship.
This is what will happen in other corporations also.
Lordship, what happened here, he was actually continuing in view of some of the officers, what I should call
That's correct.
satisfaction of his.
That
Anyway,
happens.
Lordship, anyway, that is true that he was continuing in the service. This way or that way.
All right, then let me dictate the judgment.
Lordship.
All right. Heard Mr. M. Nath, learned senior counsel appearing for the writ petitioner. Also heard Mr. L. Talukdar, learned counsel representing the respondent bank. First of all, the petitioner's case, briefly stated, is that pursuant to a selection process and on being subjected to interview, the petitioner was empaneled at serial number 2 in the panel of grade 4 employees who were required to be employed on temporary basis as general attendant bracket sweeper for the district of Kachar. Full stop. There were altogether 3 candidates whose name figured in the panel notified on 26/2/2004 by the Assistant General Manager, State Bank of India, from our regional office, Silchar. Full stop. The petitioner's names appeared in serial number 2 of the panel. Full stop. Pursuant to the panel so prepared, the petitioner was allowed to join as general attendant in the State Bank of India's Silchar Brother Bunch with effect from 15/6/2004 on the basis of order of appointment dated 15/6/2004 issued by the branch manager. Full stop. Since then, the petitioner has been continuously serving in the branch as general attendant. Full stop. As a matter of fact, at the instance of the respondent authorities, a PF account of the petitioner was also created by the Provident Fund, Pension and Gratuity Department of the State Bank of India. Full stop. Mr. Nath submits that the petitioner has been continuously serving in the post of general attendant on temporary basis. However, notwithstanding the fact that the person above him in the panel, namely Sri Shibendu Kumar Nath, has already been regularized in service, no action has been taken by the bank to regularize the petitioner's service, although he has rendered more than 19 years of continuous service till today. Full stop. That apart, comma submits Mr. Nath. The the petitioner has also not been paid salary since
My lord, March 2007.
since the month of March 2007 till date. Hence, the
My lord, to
person-
the March 2010, sorry.
March 2010. But it will be barred by limitation except
It's all right.
except
It's all right, my lord. My lord.
except 2000.
Because subsequently he was placed under a particular branch, he was daily wage he was getting. That part.
Full stop. Uh, uh, Hence, this writ petition seeking a writ of mandamus. Full stop. Mr. Talukdar, on the other hand, submits that the petitioner was empaneled due to the intervention of some of the senior officials of the bank at the relevant point of time who were satisfied with his service at a personal level. However, it is not a fact that the petitioner had served as general attendant all along since the date of his appointment with effect from 15/6/2004. Mr. Talukdar submits that in between, the petitioner was reduced to a daily wage earner, and therefore it cannot be said that he has rendered continuous service in the post of general attendant since the year 2004. Full stop. By relying upon a decision of the Supreme Court rendered in the case of Union of India and others versus Bishambar Dutt, reported in 1996, bracket close 11 SCC 341, Mr. Talukdar submits that unless the appointment was made on regular basis after due selection, the question of regularization in service does not arise in the eyes of law. I have considered the submissions made at the bar and have also gone through the materials available on record. At the very outset, it needs to be noted herein that the appointment of the petitioner was evidently made on the basis of his position in the panel notified by the State Bank of India authorities on 26/2/2004, wherein the name of the petitioner appeared at serial number 2. Full stop. The panel was evidently prepared on the basis of names being sponsored by the District Employment Exchange and after subjecting the candidates to interview. Full stop. At the relevant point of time, it is not in dispute that at the relevant point of time, filling up grade 4 posts on the basis of names sponsored by the concerned District Employment Exchange was a permissible and acceptable mode of recruitment. Full stop. Thereafter, the petitioner was allowed to join in the post of general attendant on the basis of appointment order dated 15/6/2004. Full stop. It may be correct that the appointment of the petitioner was made on temporary basis, but materials on record, more particularly the communication dated 7/5/2009, bracket annexure 8, goes to show that the appointment of the petitioner was made against the post falling vacant due to demise of the permanent sweeper of the bank, namely Premlal Balmiki, who had died on 2/12/2003. Full stop. Therefore, there is sufficient materials for this court to presume that the appointment of the petitioner, although was made on temporary basis, was against a permanent vacancy. Full stop. Subsequently, the respondents might have shifted the petitioner from one position to another, and it also appears that at some stage, the petitioner was only allowed to draw daily wages by denying him the salary and allowances. Full stop. However, there is nothing on record produced by the bank to indicate the basis on which such treatment was meted out to the petitioner. Full stop. It is to be borne in mind that a grade 4 employee appointed on temporary basis will have very little bargaining power when it comes to assignment of duty to him by the authorities, as the candidate will be in constant fear of losing his job if he raised any protest against the treatment meted out to him by the authorities. Full stop. Therefore, unless the action of the bank in converting the petitioner's temporary appointment to a daily wage earner is justified before the court, no credence can be given to such conversion in the eye of law. Full stop. In the present case, the learned counsel for the bank has failed to produce any such materials. Full stop. On the contrary, it is not in dispute that the petitioner has been constantly engaged in the service of the bank since the year 2004 till today. Full stop. Therefore, this court is unable to accept the submission of the learned counsel for the respondent that the appointment of the petitioner was either illegal and oblique or irregular, or that there was break in service so as to deny the petitioner the benefit of regularization. Full stop. Law is no doubt settled that regularization cannot be claimed by an employee as a matter of right. Full stop. However, it is equally settled law that denial of benefit of regularization to one employee while extending a differential treatment to another who have entered the service by following the same process would not only be illegal, but also highly discriminatory in the eye of law. Full stop. As noted above, the person appearing in serial number 1, namely Sivendu Kumar Nath, has already been regularized in service after his initial appointment as general attendant. Full stop. Therefore, even after having rendered continuous service of more than 19 years, there was no reason for the respondent bank to deny similar treatment to the petitioner. Full stop. As such, I am of the view that the petitioner has made out a good case for interference by this court. This writ petition accordingly succeeds. The petition is disposed of with a direction upon the respondents to forthwith take steps for regularization of service of the petitioner against the post of general attendant, bracket sweeper, against which he was appointed by order dated 15/6/2004. Full stop. Insofar as the prayer for release of arrears salary is concerned, the respondents may make an inquiry in the matter, and if found due, the arrears salary of the petitioner be released, subject, however, to application of law of limitation in this regard, which would debar the claim of the petitioner to claim arrears salary beyond the period of 3 years from the date of institution of this writ petition. With the above observation, this writ petition stands allowed.
For motion item 5.
May it please your lordship. I've got the instructions from the department. The petitioner is entitlement of gratuity, CPF payments, and with regard to the EPS scheme, my lord, that pension one, that I need clarification. Otherwise, she has been asked to bring her next of kin certificate, and we will disburse the amount, my lord. She was called in the office. She could not produce her next of kin certificate after the death of her husband, Pavitra Singh.
I was called in the office. I have been asked to produce the next of kin certificate, which I have to apply in the deputy commissioner's office. So that I am doing, my lord. I am being told that I am entitled for gratuity and provident fund, and pension I may not be available. So my prayer is that this process may go on, or whatever they want to say, that may be on record and affidavit may be filed, my lord.
No, we'll close this matter. You submit your documents and make a prayer,
Madam.
and they will consider it and pass
But
appropriate order.
regarding pension, they are saying something which I have not followed, or she also not followed. Why I'm not, after rendering 32 years of service, my lord, why my husband was not?
So let them examine and pass a speaking order if you are.
That can be, my lord.
Heard Mr. B. Chakraborty, learned counsel for the writ petitioner. Also heard Mr. B. K. Singh, learned standing counsel FCI appearing for the respondents. The petitioner's husband had died in harness on 18/8/2010 after rendering 30 years of service.
My lord, in that case, not 30 years of service, he was thoroughly absent in his service.
After rendering long years of service, full stop. According to the petitioner, she is entitled to receive family pension besides gratuity and
Provident fund.
provident fund. However, despite requests made by her before the authorities, no action has been taken in the matter till today. Hence, this writ petition. Stop. On the basis of order dated 2/6/2023 passed by this court, Mr. Singh, learned standing counsel FCI, has obtained instruction and submits that the claim of the petitioner for payment of provident fund and gratuity will be processed as soon as she submits a next of kin certificate before the authorities. However, the petitioner may not be entitled to receive family pension, as the rules would not permit the same. Full stop. Mr. Chakraborty has also confirmed that after the order dated 2/6/2023 was passed by this court, our client was summoned by the FCA authorities and asked to produce necessary documents along with next of kin certificate so as to process her claim for release of provident fund, provident fund and gratuity. He submits that the petitioner has applied for the next of kin certificate and the same will be submitted as soon as the petitioner receives the certificate from the concerned authorities. Full stop. If that be so, it is established that there is no dispute as regards the claim of the petitioner to receive gratuity and provident fund. Full stop. On the question of claim of the petitioner to receive pension, the aforesaid aspect of the matter would require proper examination by the authorities. Full stop. If the FCA authorities are of the view that the petitioner is not entitled to pension, the same has to be communicated to her in writing by furnishing proper reasons. It is only then that such issue would become justiciable in the court of law. As such, without making any observation on the claim of the petitioner to receive family pension, this writ petition is hereby disposed of by providing that immediately on receipt of next of kin certificate, the petitioner will submit all necessary documents along with a representation seeking payment of family pension before the authorities. Within 6 weeks from the date of receipt of such application, the authorities will release the provident fund and gratuity amount to the petitioner and also pass a speaking order dealing with her request for payment of family pension. If the petitioner continues to remain aggrieved even thereafter, it will be open for her to approach this court once again by filing fresh writ petition. With the above observation, this writ petition stands closed.
Obliged, man.
That's for the time being. That's for the time being.
Time being. Why time being?
She's on.
What is the matter about?
I have received the instructions. Instructions dated 7 June 2023. The petitioner, he was working as a he voluntarily offered his services for non-payment, for no payment of wages or salary or anything of the nature. Now he's seeking regularization. Doesn't have any case in my respectful submission, Your Lordship.
So you participate in the selection process?
Right now, man, I'm only overage.
Huh?
Already overage.
Then how can you honor your service? You cannot be regularized. That's the law. Overage means what is your age?
He was born in 77.
Hmm.
Now he is around 43, 45,
45. What is the upper age limit?
44, 44.
44. You make an application for you'll ask the authorities to consider it.
To consider.
In the 2014, an advertisement was issued below 14, but that was not considered below. There are some my name was on several locations forwarded with the authority for regularization. Even the staff pattern, my name is also there.
So now any advertisement has been issued.
No, at present, because the post has been filled up. The both peon as well as the LDA cum typist has been filled up.
There is no vacancy.
There is no vacancy.
Then what can be done? Nothing can be done.
Nothing is.
Engagement was done Miller against sanction post. That was the last instruction.
That
Where
was-
is the order of appointment?
Right.
Where is the order of appointment?
Separate engagement is not there.
Then how can you, no relief can be granted, Mr. Borbuya. What do you want to do by time being? You will only prolong your agony. Huh? Let me close it.
Then Miller just for the time being notice.
Okay, just for the time being, yes. Who will come? Somebody? Some senior lawyer? Who is coming?
Yes, not Mr. MS G. Goswami. He appeared last.
Oh, that's it.
Item 7.
My lord, the discase, my lord, last occasion, my lord, for us, for it.
Yes, what is the instruction?
Well, after the received instruction, but my lord, there is annexure, page 44, my lord. It was another. There is an order, my lord,
Page 44.
page 44, last page, man. Representative was my lord 24/5/2023, but here my lord 26/5/2023, my lord is.
No, he has submitted a
Yes, my lord.
representation.
So sometime you granted, my lord. Let it come after vacation, my lord, on 19th of July, my lord.
All right, interim order will
Yes,
continue.
my lord.
Heard Mr. Alan Dihinga, learned counsel for the lead petitioner. Also heard Mr. S.K. Mehdi, learned CGC appearing for the respondent who submits that instructions as called for are still awaited and therefore 3 weeks further time be granted to obtain instruction. In view of the prayer made by Mr. Mehdi, issue notice of motion returnable on 19/7/2023. Since Mr. Mehdi, learned CGC has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition, requisite in numbers, be furnished to Mr. Mehdi within 3 days from today. Let this matter be listed again for admission hearing on 19/7/2023. Interim order passed earlier to continue till then. Yes.
Mark, my lord.
Item 8.
Meet picture, Lordship.
Yes.
My lord, the claim made in this petition is for consideration of promotion from junior engineer to assistant engineer. And on the last occasion, my learned friend was to obtain instruction on this. His case is that he has passed the associate membership of the AMIC, and which is, my lord, held to be equivalent to BE degree. And accordingly, he is entitled to be considered for promotion. In fact, my lord, the issue whether this my lord certificate is equivalent to BE degree is no longer is the res integra. This has been decided, but they have made certain promotions, but this petitioner has been left out. That is why he is before.
Not, my lord, I'm just placing an instruction, my lord. My lord can dispose of this matter with this
The instruction.
All right, so we are considering your case, heard Mr. M. K. Chaudhary and his senior counsel assisted by Mr. P. Varadhar, Nayak counsel appearing for the lead petitioner. First up, the petitioner herein is working as a junior engineer in the Public Works Department. First up, the case of the petitioner is that after obtaining his diploma in engineering from the Institute of Civil Engineers, bracket India, Ludhiana, state of Punjab, he was entitled to be considered for promotion to the next higher post of assistant engineer as per rule 11 bracket 4 bracket close bracket small c bracket close of the Assam Engineering bracket Public Works Department bracket close service rules 1978. Notwithstanding the same, no action has been taken for considering the case of the petitioner for promotion. First up, Mr. Chaudhary submits that having acquired the higher education of AMICE from a recognized institute, the petitioner was entitled to be considered for promotion to the next higher rank. First up, on instructions obtained by Mr. R. Dhar, learned additional senior government advocate Assam, appearing for the PWD department, no, not a standing counsel PWD, appearing for the respondents. He submits that the case of the petitioner will be considered without any delay for promotion to the next higher rank of assistant engineer. In support of his above argument, Mr. Dhar has produced a copy of the written instruction dated 15/6/2023, issued by the Deputy Secretary to the Government of Assam, ESTT-B branch, bracket confidential cell, bracket close, PWRD, dispute, a perusal of which goes to show that the case of the petitioner for promotion is under consideration, along with 3 other similarly situated candidates in terms of Rule 11 bracket 4 of the rules of 1978. If that be so, nothing further survives for adjudication in this case. The learned counsel for both these sides have also fairly agreed to the said proposition. As such, by retaining a copy of the written instruction dated 15/6/2023 in the record of this case, this lead petition stands disposed of by providing that necessary steps be taken as expeditiously as possible, but not later than. Not later than. Yes, Mr. Chaudhary, he has given it to you. You
2 months,
decide.
my lord.
Huh?
2 months.
2 months?
2 months. my lord.
2 months.
Now just this is just before the judicial department.
Certified copy of this order. Lead petition stands. closed.
Once judicial department, my lord, releases, we will do it. Obliged.
May I be your lordship?
Yes.
Lordship, the case of the petitioner was rejected on the ground of height, lordship. Lordship will find the rejection,
Ground of height,
Height.
covered case.
lordship.
Is it a covered case?
It will be covered, lordship, but the recruitment authority is different, lordship. The recruitment authority in this case is the Assam Rifles. Lordship is passing similar, lordship has already passed some orders in case of CAPF. But this is the case of Assam Rifles.
So what do you say? We'll dispose it of?
Lordship,
Lordship,
or no?
I on behalf of the Learned Council Bivaswan Deka, who has gone to Delhi as one of his.
Let him be in Delhi. We'll
No,
dispose it of.
Lordship, like,
Let him be in peace in Delhi. Don't disturb him.
Lordship,
on the ground that they will consider
we may be allowed to obtain the instruction, Lordship,
No,
and.
no, let him prefer a appeal.
Lordship.
Let the authorities dispose of the appeal. That's all. That's
Lordship,
all.
Lordship.
Nothing more. You take down, heard Mr. M. Das, learned counsel for the petitioner. Also heard Miss, should I record your name? Your Miss?
And T Manpu.
N T Manpung, Lordship.
N.T. Maipung,
Manpung.
Learned Counsel representing Mr. B. Pathak, Learned CGC appearing in this case. Full stop. The read petitioner herein belongs to scheduled tribe category. Full stop. He had applied for the post of within quotes trade barber in response in response to the advertisement notice dated 15/2/2023 issued by the Assam Rifles authorities. Full stop. On receipt of call letters, the petitioner had appeared for the physical standard test (PST) and the physical eligibility test (PET). Having participated in the running test, the petitioner had qualified therein, but eventually he was disqualified on the ground that the petitioner did not fulfill the requirement of height. First up, Mr. Das submits that as per the advertisement notice, the minimum requirement of height for belonging to the scheduled tribe category candidate is 162.5 cm, but the petitioner's height is 163 cm. First up, notwithstanding the same, the respondents have rejected his candidature on an erroneous assessment of the petitioner's height by ignoring the fact that he belongs to the scheduled tribe category candidate. First up. It is also the submission of the petitioner's counsel that the petitioner had preferred an appeal against the said decision, but no action has been taken on his appeal till today. Therefore, apprehending that on a faulty measurement of his height, the petitioner may be permanently debarred permanently denied from securing an appointment under the Assam Rifles. This lead petition has been filed. Ms. So-and-so Learned Counsel for the petitioner submits that whether the petitioner's height is 162.5 cm or less than the same is a matter which is required to be verified factually on the basis of actual measurement. Full stop. Therefore, since the petitioner has already preferred an appeal before the authorities ventilating his grievance, she would have no objection if the read petition is disposed of with a direction upon the authorities to consider and dispose of the appeal of the petitioner in a time-bound manner.
Lordship, may I pray? Lordship, can the petitioner file a fresh appeal, Lordship? Because now he has some new documents in his hands to show.
At this stage, Mr. Das submits that petitioner has in the meantime, in the meantime, got hold of some new documents in support of his case, and therefore he be permitted to submit a fresh appeal.
Right.
Taking note of the stand of Learned Counsel for both the sides, the petitioner is granted a week's time from today to submit a fresh appeal before the
appellate authority, Lordship.
which is the appellate
Who is the
authority.
respondent number 3 here in Lordship? 4, Lordship.
If you give the wrong number, then you will have to come again before the appellate authority. If such an appeal is filed within a week from today by enclosing a certified copy of this order, the same be considered on merit and disposed of within a further period of 3 weeks with a reasoned order. A read petition stands disposed of.
Obliged, Lordship.
Highly obliged, you.
Yes.
My lord, I was imposed the punishment of my lord 7 days, my lord fine at page 48, para 4, my lord.
Will issue notice.
My lord,
Heard
maybe my
Mr.
lord, state my lord, since my lord I submitted a representation for your medical treatment.
7
My lord.
days pay, what is there to stay? If you succeed, you will get it back.
My lord,
What a case
actually,
is
what then, my lord, on at page 37, my lord, I
Sir, will
submitted,
issue notice on main and interim prayer both.
my lord.
Heard Mr. SSS Rahman, Learned Counsel for the petitioner, agree by the order of penalty, imposing a fine equivalent to 7 days pay upon the petitioner, the instant writ petition has been filed. I peruse the amendments made in the writ petition. Full stop. Also consider the submission made by the petitioner's counsel. Full stop. Mr. U. K. Goswami, learned CGC, appearing for the respondent's praise for 6 weeks time to obtain instruction. Prayer allowed NOM 6 weeks. Since Mr. Goswami has appeared and accepted notice on behalf of all the respondents, no formal notice is required to be sent. In this case, extra copies of the writ petition be furnished to the learned CGC so as to enable him to obtain instruction. Heard on the prayer of interim relief, the said prayer will be considered on the returnable date. Yes.
Item 11.
The matter will be passable for the time being, my lord. Senior is in the court number 1.
So we'll have to issue notice, compassionate family pension. Yes, your name, please.
Our Kaushik.
Heard Ms. R. Kaushik, learned counsel for the petitioner, peruse the amendments made in the writ petition. The petitioner is aggrieved by non-disbursal of compassionate family pension, which she claims to be entitled to under the law. Mr. D. Bora, learned government advocate, Assam,
1 to 6.
appearing for respondent numbers 1 to 6, and Mr. R. Dhar, learned standing counsel, Office of Accountant General, Assam, appearing for respondent numbers 7 and 8. Pray for some time to obtain instruction in the matter. NOM 6 weeks, rest you wait. Rest it's extra.
May I please, Your Lordship? Petitioner challenging the private respondent entering appointment of private respondent number 5, Lordship. With the Anganwadi worker, the Basugao Anganwadi Center, Lordship.
On what ground?
Lordship, they have respondent authority violate the advertisement guidelines, Lordship. Advertisement data page number, Lordship. 16, 20.
What is the violation?
2020, Lordship. And Assamese Vice Lordship 24. Lordship, to be
All right, we'll have to issue notice of this too.
Lordship.
Appointment has already been made.
Lordship,
Appointment has been made.
also made.
Then we'll issue notice. Heard Mr. R.L. Chutial, counsel for the writ petitioner. By filing this writ petition, the petitioner has called in question the appointment of the respondent number 5 as Anganwadi worker or helper?
Worker, Lordship.
Anganwadi worker.
The Basugao Anganwadi Center.
In the Bosagaon, is it?
Basugao, Lordship.
BOCHA, Bosagaon, Anganwadi Center, on the ground that the respondent number 5 was a regular student
Lordship.
in the date of the application, and therefore she was not qualified to be appointed as per the terms and conditions of the advertisement notice. The aforesaid allegation would have to be inquired on the basis of affidavits brought on record by the respondents. As such, issue notice of motion returnable in 6 weeks. Since Mr. A. Chakravarti, learned government advocate, Assam, has appeared and accepted notice for respondent number 1 to 4. No formal notice is required to be sent to the said respondents. However, extra copy of the writ petition be furnished to the learned government advocate, Assam, within a week from today, so as to enable him to obtain instruction. Petitioner to take steps for service of notice upon respondent number 5 by registered post with AD. Post apart on the prayer of interim relief. The said prayer will be considered at an appropriate stage. It is, however, provided that the appointment of respondent number 5 will be subject to the final order passed in this case.
Lordship.
We basically hear the petitioner for non-consideration of their promotion dispatch election recommendation of the district divisional level selection committee. They are holding the post of Khalasi Lordship under the executive engineer PC division Gwalpara. And while they are serving, their promotion has been considered by the minus of the district divisional level committee on 8/7.
This notice has to go in this. Heard Mr. L. Mohan, Learned Counsel for the petitioner. The case of the petitioners is that they are all working as Khalasi under the Gwalpara Division of Public Health Engineering Department. Full stop. Although the petitioners were eligible for being promoted to the grade 3 post, it is their grievance that no such consideration has been made by the authorities.
Recommendation made, approval not been given by.
And recommendations were also made in their favor for promotion. It is their grievance that the approval to such recommendation has been arbitrarily withheld till today. First of Ms. M. Kalita, Learned Standing Counsel for Departmental, prays for some time to seek instruction in the matter. NOM 6 weeks since Mr. S.S. Roy, Learned Government Advocate Assam, has appeared.
Respondent number 3.
For respondent number 3 and Ms. M. Kalita for the remaining respondents. 3 and what about 8? 8 also. And Ms. M. Kalita for the remaining respondents. Service notice is due to be complete in this case. Extra copy of the information will be furnished to the Learned Department Counsel. Requisite in numbers so as to enable them to obtain instruction. It is made clear that pendency of this writ petition shall not be a bar for the authorities to redress the grievance of the petitioners in accordance with that, if so advised.
May I please your lordship? Matter is regarding lordship dismissal for service lordship. The petitioner was holding a post of Nayak lordship, and a criminal case was instituted against him. He was under behind the bar lordship. Thereafter,
So we have to
yes,
issue notice. Heard Ms. S. Kananga, Learned Counsel for the petitioner. The writ petitioner was dismissed from service while he was holding the post of
Nayak
Nayak under the Assam Police
lordship.
by order dated
Lordship order dated. Order dated lordship, page number 56. Order dated 17th April 2023.
17/4/2023, which is under challenge in the present proceeding. Full stop. I peruse the grounds taken in the writ petition. NOM 8 weeks since Ms. A. Chakraborty, Learned Government Advocate Assam, has appeared and accepted notice on behalf of
All the respondents.
all the respondents. No formal notice, extra copies.
Diploma.
My lord, this matter pertains to selection and appointment of the for the post of Anganwadi helper, your lordship. Then this my lord, advertisement at page.
Who has been selected and appointed?
My lord, some recommendation has been made, my lord. The petitioner name is mentioned at serial number 2 and the respondent number 6 is mentioned at serial number 1. But in fact, my lord, respondent number 6 is outsider. From the
Select list of 29/4/23. Let the notice go, lordship, month of April.
My lord, we have come to know later on regarding the recommendation, my lord. Valid list, your lordship.
No, but respondent number 6 is that serial number 1.
Yes, your lord. He is outsider, my lord.
That has to be ascertained. That can be done in motion stage.
My lord, I have annexed the advertisement, my
That's
lord.
correct.
They have
Without
violated the
issuing notice to her, we cannot decide that.
My lord, in the meantime,
All right, heard Mr.
Some
A.
status
Raman, Learned
quo
Counsel for
in
the
respect-
petitioner, assailing the selection and appointment of respondent number 6 for appointment as Anganwadi,
Anganwadi ki work on a helper.
helper, your lord.
Anganwadi helper in the 280 number Misligao Anganwadi Center.
My lord.
The instant writ petition has been filed internally contending that the respondent number 6 is an outsider and therefore she could not have been selected as serial number 1 of the select list. That is above the writ petitioner. First up, Mr. Rahman submits that since recommendations have already been made, an interim order be passed restraining the respondents from appointing the respondent number 6. Mr. H. Sharma, learned additional senior government advocate Assam, on the other hand, submits that the select list is of
29-4.
2023, and therefore notice be issued in this case. In view of the above NOM 6 weeks, since Mr. Sharma has appeared and accepted
1 to 5.
1 to 5, no formal notice, extra copies. Registered ready on respondent number 6, 7, and 8. Hard on the prayer of interim relief. It is hereby provided that appointment of the respondent number 6 would be subject to outcome of the
Lordship.
right petition.
Not so. Obliged, Your Lordship.
The petitioner is aggrieved by non-consideration of his case for promotion to the cadre of assistant engineer from the cadre of junior.
Will issue notice. Had Mr. MP Sharma, like counsel for the petitioner. Petitioner is aggrieved due to non-consideration of his case. And the read petitioner here is serving as
Junior engineer civil
junior
under the
engineer civil
directorate of
under the Directorate of Town and Country Planning. Aggrieved by non-consideration of his case for promotion to the next higher post. The petitioner has approached this court by filing this read petition. I have perused the amendments made in the read petition. Mr. C.S. Hagarika, learned government advocate Assam, raised for some time to obtain instructions in the matter, issue notice of motion returnable in 4 weeks. Since Mr. Hagarika has appeared in accepted notice for all the respondents, no formal notice, extra copies, etc.
May it please your lordship. What is the petitioner before your lordship?
Item number 17, man. May I please have it?
Yes.
It pertains to PWD department, my lord.
Yes, what is your?
My lord, if list has been prepared, the gradation list, it is available at page 26, Annexure B. This is the gradation list prepared. And it has been communicated also to the appropriate authority, to the board, selection board. Now, my lord, many of the selected officers, including the read petitioners, they're in the verge of retirement. The last phase, only 3 months, 4 months, like that period, very limited period is left.
So this is connected with 18/1/2023 notification.
Yes, lordship.
There are series of matters pending or disposal.
Those matters are pending, lordship.
My lord, this MO is different. It was made in the on 18/1/2023. And it is not under challenge.
Of
Even
course,
the-
it is under challenge. You don't know.
Even gradation list.
There are at least how many?
That
half a
pertains
dozen
to
read
the
petitions.
earlier OM, my lord. Earlier OM 2 OM is under challenge. But these many departments are going on.
18/1/2023 is not under challenge.
Not under
You
challenge.
are sure about it?
That is what.
It's under challenge,
Huh?
lordship. What he is saying, lordship, this gradation list not under challenge.
Not under.
And pursuant to that notice, that OM lordship, this gradation list was revised, lordship.
Right.
And now he is claiming as they are retiring within 3-4 months, lordship. On the basis of this gradation list, their promotion should be considered. That is his.
Why don't you consider their case? What is the problem? If vacancies are there.
I guess, my lord.
Mr. R. Sharma, learned counsel for the petitioner, submits that his clients are on the verge of retirement. Full stop. The respondents have prepared a gradation list of superintendent engineer bracket civil, PWD, which was notified on 26/5/2023. Full stop. The names of the petitioners appear in that gradation list. Full stop. Considering the fact that there are vacancies available in the rank of additional chief engineer in the PWD department, Assam, and in view of the fact that the petitioners are going to retire very soon, Mr. Sharma prays for direction in this read petition upon the respondents to consider their case for promotion. Full stop. Mr. Nayak Lanet, standing counsel, P. Nayak Lanet, standing counsel, PWD Assam, submits that once the gradation list has been published, the department will take appropriate steps.
It
in
is
the matter.
already published. Lord. It
Yes,
has already been
it has.
published.
Since the gradation list has already been published, follow-up action will be taken by the department for promoting suitable candidates as and when vacancies arise. Full stop. Is it?
Vacancies are there.
And vacancies are there.
Acha.
numbers.
The suitable steps will be taken by the department to fill up the existing vacancies in the rank of additional chief engineer by following the due process of law. In view of the submissions made at the bar, this court is of the opinion that no practical purpose will be served by keeping this writ petition pending. Full stop. As such, this writ petition is disposed of by providing that the respondents may consider the case of eligible departmental candidate serving in the rank of superintendent engineer bracket civil, PWD for promotion to the next higher rank of additional chief engineer bracket civil in accordance with law. Without any in accordance with law.
Since my lord, time is very limited, a time frame maybe.
Since some of the candidates are on the verge of their retirement, it is expected that necessary steps would be taken without any further delay.
Highly obliged.
This petition stands closed. Necessary steps in the matter will be taken without any further delay.
May it please the Lord. By virtue of the impugned penalty order, my entire service benefits, including pensionary benefits, has been illegally recovered, my lord. And moreover, my monthly pension has also been deducted. My lord, to directly come to the order of penalty, it is without jurisdiction, my lord, totally without jurisdiction. Lordship pays 74 the penalty, my lord. A brief background, my lord, 2014, my lord, the disciplinary proceedings was initiated. In the year 2022, when I already retired from service, my lord, it was concluded, my lord. Page 74 for a moment, my lord. Last two paragraphs, the last paragraph would suffice, my lord. Hence, on perusal of allegations and charges framed against stated above, pronounced by the inquiry officer, I so-and-so ACS Deputy Commissioner Borpeta Disciplinary Authority Borpeta totally agree with the inquiry officer in exercise of powers conferred upon me under Rule 11 of the Assam Services Disciplinary and Appeal Rules is pleased to impose penalties prescribed in 7.3 and deduct pensionary benefits of Shri Bhumidhar Das so-and-so now retired amounting to rupees 19 lakh so-and-so out of the total recoverable amount of so-and-so. The rest amount shall be recovered, will be recovered at the rate of 50% of his total pension as entitled till recovery of the outstanding amount, my lord. Now, my lords would see they have exercised powers under 7.3 of the Discipline and Appeal Rules. I'll briefly read out, my lords. 7 says, my lords, nature of penalties, the following penalties may for good and sufficient reasons as hereinafter provided be imposed on a government servant, namely, number 3, recovery from pay. First of all, my lord, the penalty can only be imposed upon a government servant, my lord. Rule 2 of the rules specifies who is a government servant. It does not include a person who has superannuated from service and who is no longer a government servant. Now, they impose by taking recourse to 7.3. 7.3 says, my lord, recovery from pay. 7.3 does not say recovery from pensionary benefits. By taking recourse to 7.3, they deduct my entire gratuity and my lord, all pension.
Who is appearing for the respondents here? What is
my
the
only interim prayer, my lords, that my deduction should be stopped, my lord. Otherwise, the rest, my lord, at the time of hearing.
Do you have the instructions?
No, lordship.
We will have it next Friday. Next Friday, we'll post it for motion.
My lords, deeply obliged.
Mr. P. Mahanta, learned counsel for the petitioner, agreed by the order of penalty dated 4/4/2022, based on which recovery has been not only recovery has been made from the pension of the petitioner, but his pension has practically been stopped, providing for further recovery of the outstanding amount. Full stop. Mr. Mahanta submits that the Assam Service Discipline and Appeal bracket close rules 1964 does not permit imposition of penalty of this nature, more particularly recovery of amount from the pension of a government servant. Full stop. Mr. H. Sharma, and therefore, Mr. Mahanta seeks an interim order of stay of the recovery process. Mr. H. Sharma, learned senior government, additional senior government advocate Assam, 6 posting of this matter again after a week. So as to enable him to obtain preliminary instruction in the matter. Prayer allowed on the request of Mr. Sharma. Let this matter be listed again next Friday. What is the date? 23rd of June 2023 for motion as a fixed item. 2 extra copies of the writ petition be furnished to Mr. Sharma so as to enable him to obtain his.
Your Lordship. Well, the petitioner before your Lordship my lord, is working as a deputy general manager, my lord, in the Brahmaputra Valley Fertilizer Corporation Limited, my lord. Well, before joining this corporation, my lord, he had my lord worked in 4 other companies, my lord. Now your Lordship may turn to page 46 for a once, my lord. And this is a memorandum, my lord, where the petitioner has been asked to submit all the release orders, my lord. Page 46.
Yes.
Well, he has been asked to submit the original copies of the release orders and the experience, my lord. So the very next page, my lord, page 47 and 48, your Lordship will find, my lord, he had submitted all those, my lord, release orders, my lord. Well, thereafter, my lord, what happened, my lord? On 31/8/2019, my lord, they have issued one letter to me, my lord, page 50, my lord. Page 50. The operative part, your Lordship will find at page 51, my lord. From below, my lord, 3rd paragraph, my lord. Regarding serial number 4, Sri Datta had submitted copies of appointment letter dated so and so, confirmation letter so and so, certificate dated so and so, issued by the obtaining house loan confirming dates, but there is no proof regarding his release from Coromandel Fertilizers except the copy of resignation letter dated so and so. Next paragraph, Sri Asim Datta is hereby once again requested to submit original copies of the release of the experience as declared by him at the time of joining so and so for verification. Last paragraph, my lord. In case Sri Datta fails to submit his work experience document within the stipulated period, it will be presumed that he had no representation made on the irregularities and necessary disciplinary action shall be taken against him, my lord. Well, against it, I move the High Court, my lord. And the High Court, my lord, on my lord 11/9/19, my lord, make page 53, my lord. Well, while issuing rule, my lord, this memorandum was stayed, my lord.
Yes.
Thereafter, my lord, I got promoted to my lord deputy general manager. That your Lordship will find at page 50.
His writ petition is pending or disposed of?
Disposed of, my lord. Now they want to reinforce this one, my lord. I have withdrawn.
Disposed of by saying, where is the order of disposal?
Yes, my lord. That your Lordship will find, my lord, page 57, my lord. 67, sorry, my lord, 67.
67.
67, my lord.
You have withdrawn the earlier.
Yes, my lord, with a prayer, my lord. Now Lordship will see, my lord, page 64, my lord. They have asked me to withdraw, my lord. My lord, I have made this application, my lord. Would be pleased to page 64, my lord, my prayer, my lord. Under the aforesaid premises, it is therefore prayed that your Lordship would be pleased to admit this petition and allow the applicant petitioner the withdraw WPC number so and so with a liberty to file again, my lord. Now I am on the verge of retirement, my lord. One year, 4 months left, my lord. Now they are reinforcing that particular order, my lord.
We'll examine hard Mr. N.J. Datta, learned counsel for the petitioner, assailing the communication dated
page 50.
Communication dated 1 minute.
Page 50.
31/8/2019 issued by the Brahmaputra Valley Fertilizer Corporation Limited, Namrup. The petitioner has approached this court for the second time, internally contending that the proposed action against the petitioner based on based on memorandum dated 31/8/2019 is arbitrary and illegal. Earlier, another writ petition being WPC 6806 of 2019 instituted by the petitioner against the memorandum dated 31/8/2019 was withdrawn by him on the basis of a compromise
Yes.
arrived at by and between the parties. However, submits Mr. Datta, after the compromise was arrived at and the writ petition was withdrawn, the respondents are once again seeking to enforce the memorandum dated 31/8/2019, hence this writ petition. Issue notice returnable in 6 weeks. Petitioner to take steps for service of notice upon the respondent. What about CGC? Do you know CGC? Mr. B. Chakraborty.
Lordship, that may be got by right.
B. Chakraborty, learned CGC appears and accepts notice on behalf of respondent number 1. Extra copy of the writ petition be furnished to Mr. Chakraborty. Petitioner to take steps for service of notice upon respondent numbers 2 to 5 by registered post with AB within a week from today, hard on the prayer of interim relief, having regard to the facts and circumstances of the case. It is hereby provided that no coercive action will be initiated against the petitioner on the basis of the memorandum dated. What is the date?
31/08/2019.
31/8/2019. Impugn.
And deeply obliged.
This was item. DJ Vice.
Actually, the petitioner was constable in the ITBP. He was declared deserter. That's because he could not join after sanction leave. But see, he was suffering from COVID. Thereafter, his father-in-law was suffering from cancer. An ex parte order was passed. I filed appeal, that was also rejected.
He was declared deserted by which order?
Lordship 19/4/2021. So notice was served, but that was received by my wife, but I was not communicated because I was suffering from serious events. And my appeal was also rejected, Lords.
We can only issue notice at this stage. Heard Mr. S.C. Kyle and a counsel appearing for the writ petitioner. The petitioner hearing was serving as a constable under the Indo-Tibetan Border Police ITBP, in which post he had joined on 31/5/2009. By the order hearing number 1370 dated 19/4/2021, the petitioner has been declared as a within quotes deserter, DESERTER, unquote, with effect from 20/02/2021. The representations submitted by the petitioner and his wife were rejected by the authorities. Representations submitted by the petitioner and his wife against the order of order dated 22/2021 has been turned down by the authorities by declining the prayer of the petitioner to allow him to join back duty. Hence this writ petition. Full stop. Mr. B. Chakraborty, learned CGC, prays for some time to obtain instruction in the matter. NOM 6 weeks. Since Mr. Chakraborty has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned CGC so as to enable him to obtain instruction and file affidavit. Miss this case for admission hearing after 6 weeks.
Much.
Constable GD matter, my lord, covered case, my lord. Your lordship, page 60, my lord, is the order, my lord. Page 60, operative portion, my lord. Page 62.
How many petitioners?
2 petitioners, my lord, OBC category.
2 petitioner OBC category, Mr. S.S. Roy. Disposed of.
Obliged.
Who is appearing in this case? None appears for the petitioner. Call matter still passed on for the day.
May I please lordship? Lordship, as per advertisement dated 18/5/22, I have submitted my candidacy for the post of Gowra lordship.
And Lordship, as part of advertisement, candidates from the family of village head shall be given preference, Lordship. But and my father was a Gowra for the last 40 years, Lordship. But instead of me, respondent number 5 has
These matters have already been disposed. We prefer.
No, my lord, he is not eligible to, my lord, to apply that post. My lord, he is below 30 years, 25 years, Lordship.
Lordship, in my metric admitted, Lordship, my date of birth was wrongly recorded, and I have submitted an affidavit in the concern.
Where is the proof of your, what is your date of birth?
Lordship, my actual date of birth is 27/6/1992, Lordship, and it is recorded in voter list, NRC documents, all documents.
Why you have
Lordship.
not mentioned your date of birth in the affidavit?
Lordship, I have submitted an affidavit before the authority, Lordship.
From where do you say his date of birth is?
Lordship, may I kindly see his, my lord, school registration card, Lordship, Annexure 5, page 24.
Yes, Lordship. In the school, it is wrongly recorded, Lordship.
And now, my lord, when he was going to apply for this post, my lord, he say that my date of birth
But
was
in
wrong.
all other documents, Lordship, NRC documents, voter card
No,
documents,
nothing, only the school certificate. Your name, please?
MH Soika, Lordship.
Not Mr. M.H. Shekhar, learned counsel for the petitioner. The read petitioner herein had applied for the post of Gav Pradhan in terms of the advertisement notice dated 18/5/2022. Post of. The grievance of the petitioner is that despite belonging to the family of Gauburas, no preference has been given to his candidature as per the terms and conditions of the advertisement notice. On the contrary, the respondent number 5, who does not belong to the family of Gauburas, was selected for appointment by the authorities. Hence this read petition. Mr. Hendick, Mr. J. Hendick, Learned Standing Council, Revenue and Disaster Management Department, on the other hand, has pointed out that as per the matriculation certificate furnished by the petitioner, his date of birth is 27/6/1997, and therefore he was not eligible to apply for the post of Gauvira as per the advertisement notice dated 18/5/2022. Full stop. Hence, this writ petition is not maintainable. On a careful scrutiny of the materials on record, I find that the certificate registration card of Board of Secondary Education, Assam, annexed to the writ petition as Annexure 5, clearly mentions that the date of birth of the petitioner is 27/6/1997. As such, he was evidently below 30 years of age as on the date of issuance of the advertisement notice. First of all, even in the affidavit,
Lordship, page number 25.
In support of this writ petition, the petitioner has not mentioned his age, which clearly
Lordship,
goes to show that there is an attempt on the part of the petitioner to suppress
Lordship,
the fact that he was not qualified as per the age requirement. Full stop. Mr. So-and-so, learned counsel for the petitioner, has vociferously argued that as per other documents, including the affidavit sworn before the notary public, as well as the NRC document, the age of the petitioner, the date of birth of the petitioner was different. However, such submission of the petitioner's counsel cannot be accepted. It is settled law that the age reflected in the certificate issued by the Board of Secondary Education has to be treated as correct when conflicting materials are produced before the court. First of since the certificate issued by the board clearly mentions the date of birth of the petitioner, according to which he was not eligible to apply, I find force in the submission of Mr. Hendick. Full stop. As an affidavit sworn before the notary public. When did you swear the affidavit? When?
Lordship, I swear the affidavit on August 9, 2022, and point number 2, Lordship,
On
in
9th August 2022. Stating that his date of birth was 27/6/1992. Cannot, will not be sufficient to, for this court to presume that the entry made in the school certificate is incorrect. First step. Similar,
page number 28, Lordship.
yes,
Annexure 7.
what is that?
And also, my lord, it was issued on, my lord, 1/4/23 and registered on 29/3/23.
The other documents annexed to the writ petition are not found
At this,
reliable at all to presume that the petitioner's date of birth was different than what projected in the school certificate. As such, this court is of the unhesitant opinion that the petitioner was not eligible to apply for the post of Gavura. In view of the above, this writ petition is held to be devoid of merit, any merit, and the same is accordingly dismissed. Report given Mr. S.S. Royal and the government advocate Assam for
Lordship,
for numbers 2, 3, and 4. Yes.
Lordship, in the voter card, I have also, it was mentioned it.
I can pass a more detailed order, but there will be cost. The school leaving certificate is final. Unless that is changed, if you have any amount of document, go through the judgments, do some reading.
Lordship, I have applied for correction. of
Yes,
the-
you apply, but the division bench judgment is there. Just 2 months back, there is a judgment of division bench. Read the judgments, then you will know where you stand. It has been held that nothing else will work. Only the school, supposing school certificate says one and there are other card, these, that says another, only the school certificate will be accepted. That's the law. Read it, next time it will help you. Next matter, please.
Right, Lordship.
May I please?
Yes.
This matter relates to selection of dresser under the Directorate of Health Services, Assam. My lord, the selection is carried out.
Selection of what? Dresser.
Dresser.
What is that?
Dresser under health department.
Health department.
Dressing, my lord, car injuries and
Injuries and surgery dressing. So the selection process is entirely in violation of the provision of the advertisement itself, my lord.
What is the
Advertisement,
violation?
yeah, advertisement is at page 35. Kindly. At page 35, on the right-hand column, clause 7, it provides weightage for service under NHM. Many contractual employees are working under NHM as nurses, paramedics. They may be given weightage of 2 marks per year of service completed under NHM, subject to a maximum of 20 marks, so that they can be given suitable and justified preference. Admittedly, no weightage was given. Kindly turn to page
47, my lord.
44.
So the petitioner was the earlier employee of NHM.
44.
Petitioner was earlier employed under NHM.
Yes, my lord.
Your case is that no weightage was given to him.
No weightage was given to the any candidates.
No, you talk about your client.
Yes, no, he was not given any weightage. And also the respondent number 3, who was selected, he was barred by upper age limit, and he does not have mandatory experience for 3 years, which advertisement provides for.
All right, heard Mr. O. Lashkar, learned counsel appearing for the writ petitioner, assailing the selection of respondent number 3 for appointment in the post of dresser, DRESSER within court, under the Health and Family Welfare Department, Assam. Mr. Lashkar submits that the said respondent was not qualified under the advertisement notice for being selected for the post. Moreover, it is also the submission of Mr. Lashkar that the requisite weightage for the past experience of the petitioner due to his tenure under the NHM was not given in the selection process. despite necessary provisions have been made in the advertisement notice. Hence, a prayer has been made to set aside the appointment of respondent number 3, who is to Mr. D.P. Bora, Learned Government, Learned Standing Council, Health and Family Welfare Department, Assam, raised for some time to obtain instruction in the matter. NOM 6 weeks since Mr. Bora has appeared and accepted notice for respondent numbers 1 and 2, no formal notice, extra copies. Petitioner to take steps for service of notice upon respondent number 3. Heard on the prayer of interim relief, the said prayer will be considered in the returnable date.
Lordship, similar matter is fixed on Monday, Lordship. It came on 14/6, similar matter, WPC 3324 of 2023.
That was not similar, my lord.
Here just the appointment later.
Appointment, in this case, my lord, one has been made, my lord. But posting has been, my lord. Kindly see my lord, page 37.
Lordship, similar
Page
matter
37.
came in court 2.
Term and condition 8.
Similar matter came in court 2 today. He appeared. That is also fixed on Monday, Lordship. That was also fixed.
What is the case number?
The one which came on 14th was 3324 of 2023. And the one which I appeared today, just now, Lordship, it is 3505 of 23.
Heard Mr. Arrestrawn and counsel for the petitioner. Also heard Mr. U. Pamenu, Learned Standing Council, Health and Family Welfare Department, Assam, who submits that a similar matter has been fixed before the court number 2 again on Monday. And therefore, this matter be tagged along with WPC number
3324 of 2023 and 3505 of 2023.
In view of the prayer made by the Learned Departmental Council, registered to list this case again on Monday along with.
Highly obliged.
Matter, item 6.
Apologies for not being in first round. Lordship, this matter came up 2 weeks ago. When your lordship asked for instructions. The petitioner has been working as a LDA cum typist since 2007. That was when their office was actually opened. And
They've got the instructions. He was working on honorary basis. There is no engagement.
yes, your lordship, which is why we've come here for a prayer for regularization. Almost all regularization, lordship, is on voluntary basis. They have engaged me for 16 years without any payment
When is
against
the order of engagement?
there's only a certificate that I have been engaged. Lordship, page 33. It's by the person I directly report.
So anybody will put somebody and say you work and then after some time. they
Lordship,
will-
if you've taken, that is the law of Uma Devi, Kesri and Prem Singh. That if you've taken voluntary services for so long and it's against a sanctioned post.
No, who has appointed your client?
Lordship, respondent number 4, Child Development Project Officer, and he is certified at page 33. Lordship, at page 33, see, this is to certify so and so is working in Borkala ICDS project non-officially in as grade 4 from the time of inception of this project. And when they had to send the pattern, grade 4 staff pattern, and my name is there. So there's no dispute that I'm working. Lordship, I'll rely on MLK Street. Lordship is already aware. MLK Street is to Lordship, there was an advertisement. They never attempted to regularize this post. There was an advertisement, we applied. Respondent number 4, in fact, even passed it on to respondent number 3. Lordship, para 5 is Uma Devi. Lordship 6, they notice Uma Devi. I will not take your lordship's. Lordship is read and again. Para 7. It is evident from the above, there is an exception to the general principles against regularization enunciated in Uma Devi if the following conditions are fulfilled. 1, the employee concerned should have worked 10 years or more in a duly sanctioned post without the benefit or protection of an interim order. In other words, the state government or its instrumentality should have employed the employee and continued him in service voluntarily and continuously for more than 10 years. We worked for 16 years without any protection of the law.
Which post? Which is the sanction post?
LDA cum typist. Lordship may see at page 25.
Have you been receiving salary?
No salary, your lordship.
Then how can you serve against a veteran?
Lordship, they have taken my services. That they have not paid service is even a bigger ground for regularization. Page 25, your lordship.
No, Ms. Goswami, I'll accept your submission if you can convince the court that the appointment was against a sanctioned post pursuant to a selection process. If these two things are met, you have,
Lordship, there was
you
no
have the
selection.
order.
In 2007, this office was built, open, and it was open in petitioner's brother's premises. They needed a grade 4 employee staff. They engaged him. This is 2007. They've been engaging him since then without any salary.
Who
so
is
to
that
speak.
they? Who's that
This is Lordship, the Child Development Project Officer. Lordship, may kindly take a look at page
You
25.
include him personally, we'll ask him to pay a part of his salary to him.
Lordship, may see
But
page
no order of
25.
regularization can be passed.
Lordship, the
If
law is if you've
implead
taken
him,
somebody
if you
served
implead
on-
the CDPO who has done it, maybe we can consider that part of his salary will go to.
Because
the
plain
petitioner.
says that if you actually take services and are not regularized, it's amounting to adopting.
Correct, but
exploitative.
provided the entry is through a legitimate move. Somebody is saying, all right, you can come and keep working here. That's not a mode of appointment.
Lordship, that is why Uma Devi came and exceptions came. The people were doing that. Authorities were doing that. They were appointing people. Lordship, may kindly take a look at page 25. Because there was an advertisement for regular post. We applied and they've not done anything about it. So they choose. Lordship, what is Uma Devi? Uma Devi frowned on state authorities because they chose not to regularize. They chose to go ahead with ad hoc. That is the system that they follow. And then you take my services and you don't bother to regularize nor pay. Lordship, page 25.
Would
This
you
is
like to implead the person concerned who had
not the person concerned. Our respondent number 4 is the authority I report to. And that's page 25. Your Lordship, may kindly one indulgence, page 25.
Yes, page 25 is before me. Yes.
In inviting, there was an application, there was an advertisement for post regular, we applied. So this is respondent number 4, who I report to, is forwarding to his immediate senior. In inviting a reference, subject matter, I am forwarding an application for the post of LDA cum typist, advertisement so-and-so. Next paragraph. Mr. So-and-so, which is the petitioner, is extending his voluntary service as grade 4 for last 4 years without any honorarium, has hence therefore considered. This is the child development officer who under
This
whose
is his understanding. This is not, he does not lay down the law. It is his understanding of things. We'll go by what the law says.
Lordship, the law says if the state or the instrumentality have employed the employee and continued his service voluntarily and continuously for more than 10 years, it is incumbent on the state to regularize. And the employee is entitled to regularization. Uma Devi casts a duty on the state or instrumentality to take steps to regularize service of those irregularly appointed who has served more than 10 years without benefit of protection. Uma Devi directed as a one-time measure. Then Lordship, paragraph 11 is important. The true effect of direction is that people who have worked for more than 10 years without protection in vacant posts, this post has been lying vacant since 2007, your Lordship, are entitled to be considered for regularization. Lordship, the practice is there. It is a state adheres to this practice, and that is Uma Devi, your Lordship. They frown on the practice of the state that you don't come up with proper regularization, proper advertisements. You ad hoc appoint, and then you choose to regularize at will. That is the genesis of Uma Devi. And then Uma Devi said 2 conditions. There must be a sanctioned post, which is our case. You must be suitable for it in terms of qualification, which we are. And you have 10 years without interim.
You file your affidavit. All right. But
Lordship, they have not 16 years he's been working and they have not advertised. They must not now. So I'm already 45. That much protection will also be
no
given.
advertisement has been issued.
Only once when we applied, which I showed you. One advertisement happened in 2014, after 7 years of me working, and I applied. Nothing happened of that.
Right now, there is no advertisement.
As of now, nothing. Unless they want to be vindictive, you're not sure.
No, if they do it during the
They will come.
pendency.
Yeah, yeah, sure.
But Ms. G. Goswami, like counsel for the petitioners, the petitioner's case in a nutshell is that he has been rendering voluntary service in a grade 4 post. In the Borkhola ICDS project since the year 2010, is it?
2007.
2007. Notwithstanding the same, the respondents have not taken any steps to regularize his service. By referring to the decision of the Supreme Court in the case of state of Karnataka and others versus Hemant Kasari and others, reported in 2010, bracket close 9 SCC 247, Ms. Goswami submits that the state is bound to regularize this service of employees who have served for more than 10 years without the assistance of any order of the court, full stop. Mr. D. Bora, learned government advocate Assam, submits an instruction that there is no order of formal engagement of the petitioner in any grade 4 post. However, materials and record prima facie indicates that the petitioner was asked to render his service voluntarily against the said grade 4 post. Therefore, the issue raised by the petitioner's counsel will have to be addressed on the basis of affidavit filed by the respondents. The learned government advocate therefore must be granted time to, as such, the learned government advocate must be granted some time to obtain instruction file affidavit. NOM 6 weeks. Since Mr. Bora has appeared and accepted notice for all the respondents, no formal notice, extra copies, etc., etc. The Departmental Council shall positively file affidavit on or before the returnable date, bringing the stand of the department on record.
Lordship, on the last occasion, they were willing to consider a prayer D, which is really outstanding.
There is no outstanding as such. Your Lordship, that your Lordship may
The
also
also
observe.
appeared last time said that we are okay with that.
If I may. Your Lordship, as I have stated in the instructions itself, there was no wages or any salary paid. And he was actually,
The prayer for interim relief will be considered after the affidavit is filed by the department.
Obliged, your Lordship, obliged.
For admission, I can 25 pass out.
My lord, in this matter, with all humility, my lord, I was supposed to get an instructions from the department, my lord. There was some inadvertent, my lord, delay on our part only. We could not send the communication, my lord. And my friend just informs me that there is some development. So, my lord, let this matter may come up after 10 days so that I can get the instructions. My
What
lord.
is the development? What is this matter?
Yesterday, my lord, an inquiry was conducted
Hmm.
by the additional civil engineer, my lord. And the documents were found to be issued by the proper authority as claimed by the petitioner. That is to be reported.
That matter, I don't have that any instructions. He told me that, my lord. So my prayer will be, my lord, let the matter may come after 10 days. In the meantime, I will get whatever instruction is
What
forthcoming.
is the issue here?
Issue, my lord, almost similar of the previous case. My lord, they said that they have been, the writ petitioner is working in a division as a computer typist. We said that we never appointed you. But my lord, yes, one executive engineer, he issued some certificate, my lord. Certificate, experience certificate.
Not all on, my lord,
Ah.
all the executive engineers.
My lord, that is that. But if we go by the records, we never issued any appointment letters.
All right, Mr. Ayat Sekar, learned counsel for the petitioner is present. Mr. R. Dhar, learned standing counsel, PWD Assam submits that due to a communication gap, the instructions sought for from the department could not be obtained. As such, this matter be posted again after 2 weeks. Since the prayer made by the learned department counsel is not opposed, same stands alone. Let this writ petition be listed for admission hearing again after 2 weeks.
26.
Yes.
My lord, it is related to my lord, promotion appointment to supervisor from Anganwadi worker, my lord. My lord, she was selected, my lord, in written test. And then, my lord, at the time of final selection, my lord, her name has been dropped, my lord, and she has been working since 1996, my lord. At the time of filing this writ petition, my lord, already she had 22 years experience. My lord. And what they have done, my lord, the advertisement was, my lord, for for reserved quotas, madam. That is at page, madam. And she had also extra, she
Yes,
had
why
extra.
she was not selected?
Lordship, the marks, Lordship will kindly turn to page number 12 of our affidavit in opposition.
Hmm,
Therein her marks have been given.
yes,
Serial number 891,
page number 12.
12 of our affidavit in opposition, Your Lordship. Serial number 891.
And this post is for SC quota, madam.
Serial number 891.
891, Your Lordship. Onu Das.
Hmm.
41, and this is for written and this is for Viva, 8.66 or 49.66, Your Lordship. Then, Your Lordship, will turn to page number 20. This is the marks that she has obtained. We are giving the marks here, Your Lordship. Then, Your Lordship will turn to page number 26.
Yes.
The lowest that has come, Your Lordship will see. Ida Das, that is 1, 2, 3, 4, 5, 6, 7, 8, 8, almost like in the 8th row, Your Lordship. Your Lordship will see that's the lowest mark that has come is Chuma Das, Your Lordship. 9th.
But it's page number 26, half the things are covered. This is what you have given.
It's there. Page number 26, Your Lordship. Your Lordship can take mine. As of
No, but in the court's copy, this is what you have given. Covered.
page 26. But let me check it. It should not have been, Your Lordship. The one half page is covered, Your Lordship, because we wanted to show the what is the chart all about, Your Lordship. File 2. May I? Just what a bonus. Also, that was the.
So have you filed rejoinder?
Yes, ma'am.
Yes.
They are saying you did not meet the cutoff mark.
No, my lord, there is nothing, my lord, in the proposal, my lord. I'm coming to that, my lord. There is nothing like that, my lord, 50% has to be the cutoff marks, my lord. And my lord, this is for 25% reserve quota, my lord.
This matter will take time. We'll hear it on a admission column. Disposal at admission column. Had Ms. M. D. Chaudhary and counsel for the petitioner, also had Mr. C. S. Hazarika, and government advocate Assam appearing for the state. It is submitted at the bar that this matter is ready as regards planning, pleadings and can be taken up for disposal. Since the controversy involved in this petition pertains to non-selection of the petitioner for promotion, upgradation to the post of superintendent.
Supervisor.
Supervisor under the
Supervisor.
ICDS project, this matter will require detailed hearing. As such, the institute list this case for admission hearing list this case again in the column of disposal at the stage of admission hearing immediately after the reopening of summer vacation.
My lord, I have a request, my lord. I have got one item, my lord, 50, item 50, my lord. That is contempt matter, my lord. Can it be taken up now, my lord? Because I have some problem, my lord. If possible, my lord, I'm not forcing anybody.
Why? What is the
50,
problem?
my lord.
You want to go home early?
No, my lord, I've got so much. I've got some problem, my lord. If your
What is
lordship.
there? What is there in 50? Who's the other side counsel?
Yeah, Mr. Nath, my lord. Mr. Nath is there, my lord. It's a contempt matter, my lord. They have,
Order has been complied with.
my lord complied, but after 1 year, my lord. After 1 year, and a lordship had beforehand also have taken this case, my lord.
You will require a detailed hearing. That is
Ah.
not possible today.
My lord, then, my lord.
Then will come,
Yes, my
the
lord.
order has been
On the
complied
same
with.
date, my lord.
Lordship, I have given the copy of the order. Lordship, file is there.
My lord, after 1 year, my lord, the contempt has already been committed. My lord.
You file appropriate proceeding.
My lord.
After 1 year, it has been complied with.
Yes, my lord.
So then what remains now?
My lord, they are actually, the respondent is a contempt now, my lord. Because they intentionally have, my lord, all of them, my lord, intentionally have not done anything for the petitioner, my lord. And this is for the pensionary benefit, my lord. And last time, my lord, your lordship had said that there
If
is
it is
no
a
mandamus
willful
direction.
delay, then you file a writ petition, will allow you, will
My lord,
give you
problem is
compensation.
that he is already depriving of his pension, my lord.
Copy
He has
of the
been
order
given-
also I have
We will
given.
not put
Just
them
a
into
minute.
jail.
My lord,
We will not put them into jail after the order is complied.
obviously, my
So
lord.
only relief you can get is compensation.
My lord, yes, my lord, it is so, my lord,
Heard Ms. M.D. Chaudhary, learned counsel for the petitioner, also heard Mr. M. Nath Manas, senior counsel appearing for the respondents. It is submitted at the bar that the order of the court has already been complied with, but there was willful delay of more
Yes,
than
ma'am.
1 year in
Yes, ma'am.
complying with the court's order,
yes, my lord.
for which the respondents are liable to be punished for committing contempt of court. Full stop. Since the order has already been complied, the order of this court has already been complied with, I am not inclined to keep this contempt case pending. However, if the petitioner can make out a case showing deliberate negligence, showing negligence on the part of the respondents in complying with the court order, thereby leading to injury of his right, then he would certainly be entitled to
Yes, my lord.
a remedy under the law, which may include payment of compensation to be recovered from the salary of the officers responsible for such willful delay.
In
As
appropriate
such-
forum, in appropriate forum.
As such, by granting liberty to the petitioner to to institute appropriate proceeding, contempt case stands closed. Yes, you can now go home early. Take some rest. It was
I'm so
ideal.
thankful, my lord. I'm so thankful.
My lord, during the pendency of the my lord, earlier petition, my lord, and there is in my lord, there wasn't my lord, the order, my lord. The respondent authority, my lord, issued a subsequent transfer order, my lord. So, my lord, the second time, my lord, the petitioner approached with my lord, petitioner's child, my lord, is a my lord, disabled child, my lord. On that ground, my lord, there is my lord.
There is an interim order operating.
My lord, in first one, my lord, there's the interim model, my lord. My lord, is 2019, my lord, 12 July 2019.
The transfer order is dated
12 July 2019, my lord. Now
Initially, it was my lord 12/7/2000, now my lord 2026/4/2023.
another transfer order.
Yes, my lord, it's miscommunication.
Yeah, lordship, because it was passed 2019, but they have not given effect to that. That is still kept in advance, lordship. And we
Sec-
have,
Second one is Cape events, my lord. Because of some miscommunication, there, my lord, so my lord is because of this petition, my lord, there is stay order, my lord. It's continuing from 2019, my lord. So some. they have to-
But you have already got more than 4 years benefit of
yeah.
this. Transfer order cannot be for eternity.
Yes, my lord, there is my lord, the specific guidelines, my lord, even my lord, the guideline, my lord, the.
Well, we'll hear the matter then after vacation.
Yes, my lord, until 19th July, my lord, if possible.
Heard Mr. Ellen Dehinga, learned counsel for the petitioner, also heard Mr. S.K. Mehdi, learned CGC, as well as Ms. B. Sharma, learned CGC, appearing for the respondents in the respective writ petitions. On the request of Mr. Mehdi, these matters are directed to be listed again on 19th of July 2023 as fixed items for admission hearing. These matters will be taken up for disposal on the next day.
second case, lordship, notice not. given.
Second case, notice not sent.
Not because of this, my lord, penance of this requisition, my dishonorable could direct it, my lord, to instruction only, my lord. My lord. So, my lord, only this, because then there is no effect of that order also, my lord.
Interim order passed earlier to continue till then. We'll see, we'll dispose
Yes,
of
yes.
this.
Item 29.
May I please, my lord? My lord, the pleadings are complete, my lord, here. It's with regard to a de novo proceeding. After, my lord, there was a criminal case, there was a departmental proceeding. Departmental proceeding, my lord, criminal case FR, exonerated, departmental case dropped. They had set up a judicial commission. The Judicial Commission gives some report, my lord. And thereafter, the second, on the same fact, second proceeding is drawn against me. I file my WS, therein taking all these pleas, not considered. Now I am before your lordship.
Matter will have to be heard.
Not heard.
What to do today or after? After vacation. Mr. UK Nair, learned senior counsel for the petitioner, as well as Mr. H. Sharma, learned additional senior government advocate, also submits that since pleadings have been exchanged in this case, the writ petition can be taken up for disposal. As such, let this writ petition be listed again in the first week of August 2023 in the column of disposal at the stage of admission here, by reflecting the name of learned counsel for both the sections. Yes.
My lord, here I have assailed the penalty that was imposed upon me in a departmental proceeding. Concurrently, there was a criminal case, honorably acquitted. So I have taken a plea, my lord. So this also, my lord, will have to be finally.
Same order, second week of August 2023.
Second.
Madam, appears for the petitioner on call, Mr. H. Budagohai, learned counsel is present on behalf of the.
For respondent, all the respondents, SBA.
For the respondent, since the petitioner's counsel is absent today, this matter stands adjourned for 4 weeks.
My lord, affidavit has not been filed, my lord. In the, my lord, I'll file my affidavit. In the meantime, subsequent development taken place, my lord. Examination had been held. Now, only thing is that, my lord, results had to be declared, my lord. There is a order, my lord, not to declare without the leave of the court. He has also participated in the exam.
Notice was issued on 33/2022, and a restraint order was passed, my lord. Lordship will kindly present that order, 33/2022.
So let them publish the result.
No, my lord, then we will be prejudiced, my lord.
They are working, they have participated in the process.
You have
my lord.
participated.
You participated.
Because by the leave of the court, we have participated, my lord. But lordship will, without affidavit, how can they, my lord? Third party right will accrue, my lord. And they have not.
Now, what is your grievance here?
My lord, we are working since 9 to 10 years, my lord. Either they regularize because they have advertised our post, or they might not give us some relaxation, weightage, my lord. Now, my lord, without adjudicating the issue.
So therefore, if the result is published and you get selected, then your grievance is taken care of.
No, my lord, that will be taking a chance.
No. That will be
No, my lord,
without prejudice to your rights and
No, my lord.
contentions.
They have not filed their affidavit since March to 2020.
Oh, Mr. Patwari, these
They
are
have not
matters.
filed their stay
We'll
vacation.
leave these things to the judge.
True, my lord. That is true, my lord.
There will be without prejudice to your rights. What is your problem? You are appearing, Mr. Chaudhary. Let them publish the results without prejudice to rights and contention of your client in the matter, because you have participated in the process. If it turns out that they are already selected, we'll close these cases.
My lord, before, I don't think result is ready because they have
Result will.
they have not filed any application
If
seeking
lordship
their
is at
leave, my
liberty,
lord.
will publish the result, my lord. They have participated
No.
and
My
they
lord,
now they are
no.
continuing with the.
I think they have issued an advertisement, my lord. They say, so-and-so candidate have been shortlisted for appearing in personal interview to be held on the following schedule, 13/6, 14/6. So after interview, my lord, they will finalize the result. That stage has not come. They issued an advertisement in the
Well, you
newspaper.
file an application.
Yes, let them file an affidavit.
Senior counsel for the writ petitioner, Mr.
Definitely.
S. Boral and his SC GMC submits that.
My lord, GMD.
GMD submits that in terms of the leave granted by this court, the selection process has been held wherein the petitioners have also participated. Therefore, the GMD authorities are proposing to file an application seeking leave of this court to publish the results of the selection process. In view of the above, let these matters be listed immediately after the IA is filed by the GMD.
Deeply. When your lordship says take leave, that is the purpose, my lord. When you complete file an application, then considering the merit of the case, lordship will allow them. Well, item number 32, I think lordship has fixed some other date, Nikki. Oh. Item number 32, my
It
lord.
has been adjourned for 4 weeks.
Oh,
Why? Anything you want to say?
some urgency is there, my lord, regarding some promotion in the career, my lord, of that officer in the state bank. Can it be, my lord, on 26th, my lord? Or after the vacation?
Let it be after vacation.
Okay.
After vacation, list after vacation.
May it please your lordship. Lordship, as the matter was fixed up for hearing, my lord, it doesn't come up in the list, my lord. My lord, can it be fixed up for hearing? All pleadings are completed, my lord.
What is this? Yes. You are appearing in this case.
My lord, I'm appearing in this case, my lord. All pleadings are completed. On last occasion, we have
My lord,
agreed for hearing.
I am for the private respondent, my lord, who was selected and who had joined. There was an interim order, the interim order staying my appointment after I joined. My lord, I had filed an IA, my lord. And lordship was pleased to direct that the IA would be taken up along with the petition for disposal.
So IA has been listed today.
No, my lord, the order is passed that it will be heard along with the writ petition.
Along with the writ petition.
For
My lord,
disposal.
may fix up for hearing, my lord, after vacation, my lord.
My lord, and I have a small prayer, my lord. Would my IA be treated as an affidavit in opposition, my lord?
Heard Ms. So-and-so counsel for the petitioner who submits that this matter was earlier directed to be listed for hearing. Therefore, an order be passed fixing a date of hearing of this writ petition immediately after the summer vacation. Mr. P.D. Nair, learned counsel appearing for the respondent number
5.
5 submits that the interlocutory application filed on behalf of this client be treated as counter affidavit in the writ petition. In view of the above, registry to list this matter again on 10th of August 2023 for hearing as a fixed item along with the IA.
Admission hearing, my lord.
Admission hearing.
Deeply obliged.
Deeply obliged.
Here the respondents have filed their affidavit today. Considering the fact that it's a matter of removal from service, may I pray for a date for admission hearing after the vacations?
Ms. D. Burgoyne and counsel for the petitioner submit that counter affidavit on behalf of the respondents has been served upon her only this morning, and therefore she be granted 2 weeks time to file rejoinder if so required. First up, the learned counsel for the petitioner has also prayed for posting this matter for admission hearing after the summer vacation. Taking note of the prayer made by Ms. Burgoyne, this matter is directed to be listed again on 17th of August 2023 as a fixed item in the column of disposal at the stage of admission hearing. In the meantime, rejoinder affidavit, if any, be brought on record.
Published.
May it please your lordship. Lordship, I'm appearing in item number 39, lordship.
Who is appearing in 38?
Well, the matters are covered with your lordship's order dated 31 to 2023.
What is the matter?
The 3 years period, minimum 3 years period.
The matter pertains to completion and upon my lordship. I have challenged the SLC meeting dated 21 to 2022 as well as the OM dated 1/6/2015. By which it has been provided that appointment and compassionate ground.
All right, just a minute. Who is appearing in item 38?
38, my lord, Mr. S.K. Talukdar is appearing. My lord, he is on legs, my lord. Can it be the
We'll dispose it of reconsideration, that's all. Heard Mrs. Where is the consideration? Which page?
My lord, after some time, my lord, time being, my lord.
I am disposing it of by allowing it,
I'm
or
sorry, my
I'll
lord.
dismiss it
Sorry, my lord.
for some time. Which page is the resolution minutes of the SLC?
Item number 38, your lordship. It's at page number 38, dated
number
22/1/2022.
And which part is the petitioners? Petitioners parties? What is petitioner's name?
Maminul Hussain.
Not at all. Item 38 is Ashikur Rahman.
I'm sorry, Your Worship, I'm looking at the item at 39. Sorry, Your Worship. Page 37, Your Worship.
You don't have the file, is it?
My lord, so sorry, my lord.
We'll have it after vacation. On the prayer of Miscellaneous Counsel for the petitioner, leave this case after the summer vacation. What is your case, Kimi? Item 39.
38.
Which page?
Lordship, DLC has recommended lordship, SLC, page 10, lordship. That petitioner's part is the page
Page
39,
10.
lordship.
Page 10
Page,
is
annexed 10, page 38, lordship. That is the minutes of the SLC meeting.
yes, and where is the name of the petitioner?
Lordship, page 39, lordship. Page 39, 2,
Page 39.
lordship 2. Lordship, may I read?
Five percent quota is not available.
Yes.
How is it covered then?
Your Lordship, they have, for making application for compassion appointment provided in each case, the government servant has balance of minimum of 3 years of service. That's why it was actually.
Lordship, it has been challenged, lordship. Similarly situated person is.
Yes, you are miss.
As does.
Which as does learned counsel has appeared for the petitioner. Mr. D. Bora, learned government advocate Assam is present on behalf of respond number. Here for respond number.
Your Lordship, respond number 4 and 5.
Respond numbers 4 and 5. Mr.
RB Goswami, my lord.
RB
My lord, my
Goswami.
senior's name will be recorded. MD Bora, my lord.
This is MD Bora, learned standing counsel.
1, 2, 3, and 6.
Is present on behalf of respond numbers 1, 2, and 3.
Six.
1, 2, 3, and 6.
My lord.
The read petitioner hearing had submitted an application seeking appointment of on compassionate ground against a grade 3 post after the premature demise of his father. First up, the application submitted by the petitioner on 18/6/2016 was duly recommended by the DLC in his meeting held on 14/7/2017. However, the recommendation of the DLC was rejected by the state level committee, SLC, in his meeting held on 22/1/2022 on the ground that the father of the petitioner did not have 3 years of service left to his credit at the time of his demise. First up, the aforesaid decision was apparently taken by relying upon principle 1 of the government OM dated 01/06/2015. First up. So this DCRG leave in by referring to the decision of the SLC, Ms. Das submits that clause 1 of the OM dated 1/6/2015 has been set aside by the learned single judge of this court by judgment dated 30/1/2023 passed in connection with
1646/2021.
number 1646 of
2021.
2021. Although the state has preferred an appeal, no interim stay has been granted by the division bench. As such, the minutes of the selection committee be set aside and the matter be sent back for reconsideration. First up, Mr. Bora, learned government advocate, Assam submits that similar orders have been passed by the court in similar read petitions, and therefore he would have no objection if the same order is passed in the present case as well. Same is the stand of Illinois Standing Council, Cooperation Department, Assam. In view of the above, the resolution adopted in the meeting dated 22/1/2022. Qua the writ petitioner is hereby set aside and the matter is remanded back to the SLC for taking a fresh decision. Dehors clause 1 of the OM dated 1/6/2015. The aforesaid decision be taken as expeditiously as possible, but not later than 6 months from the date of receipt of a certified copy of this order. Writ petition stand disposed of. Yes.
Obliged lordship.
May I please, Malad? Malad, this matter pertains to the removal of that Borpeta Road Municipal Board Head Assistant. There was he was removed, he comes up before this honorable court. This honorable court interferes with the matter and remands back the matter saying that do it de novo, complete it within 6 months. They wait till the last moment, a show cause is issued. I reply. Thereafter, my lord, enquiry officer is appointed. I appear before the enquiry officer. A questionnaire is given to me. I reply to that. Thereafter, my lord, all of a sudden I receive an enquiry report, undated enquiry report, received by the board on 17/12, wherein, my lord, around 8 witnesses were examined, all behind my back. And then they come to a conclusion that I am guilty, and finally the board, my lord, removes me from service. On the last occasion, my lord, will have the order. After repeated, my lord, adjournments, my lord gave them a last chance to file an affidavit. No affidavit has been filed.
Our affidavit will be under preparation, will be filed. When on the last occasion, as a matter of fact, my lord, they have raised another issue that the last order passed by the Supreme Court, so far as the payment of subsistence allowance is concerned, that was not complied with. And my learned friend appeared when she was actually to file an affidavit. So we'll file an affidavit when Lord will give us.
My lord will see whether the
Lordship will give us 10 days time. Let us file the affidavit in the writ petition, my lord, and then Lordship will dispose. Otherwise, it's a 2023 matter, my lord.
But my lord, the man has been removed illegally, and my lord was also prima facie satisfied on the very first day, my lord.
In the case of dismissal, my lord, departmental proceeding was initiated, it was conducted. If they allege that it was not fairly conducted.
Who is the person? Let him come. We'll give a personal appearance to him.
My lord,
Personal appearance.
my lord, the enquiry
Last
officer.
chance was given last day.
My lord, last chance was in.
Yes, yes.
Last
We have not
chance-
seen the order, Mr. Naganda.
No, my lord, last chance was in respect of a different issue. Lordship will. My lord, so far as the affidavit in opposition against the entire writ petition is concerned, my lord, I'm assuring sound report, there's no difficulty in filing that. Another issue was, my lord, raked up, that is why the.
Mr. Majumdar, please see the order of 12/6/2023. Have you seen that order?
My lord, that is in respect of
That is
subsistence
the
allowance.
problem.
Subsistence allowance.
No, we said you have to tell us what has been done, otherwise
My
the
lord,
court will take action in the matter. Nothing has been done.
my lord, so far as this subsistence allowance payment issue is concerned, my lord. In fact, a affidavit was prepared. What I have found is, my lord, in fact, that is why I will be asking for some more time. What has happened is, Lord, will kindly look at the order passed by the Supreme Court on the last occasion, in the last writ petition. That was disposed of on 20th of December 2021, whereby your lordship directed that there should be a de novo inquiry, and he will be under suspension for the purpose of conducting the inquiry.
Mr. Nair will pass an order on Tuesday.
Lordship.
My lord,
But Mr.
my-
Majumdar, your client is coming to the.
No, my lord. Your
Yes,
lordship-
yes.
My lord, lordship will kindly see one thing. It's a case where a person, there is only a person who writ petition has come only for the purpose of alleging that the inquiry was not conducted fairly. What he is entitled is a fair inquiry, my lord. If he alleges that inquiry was not conducted
But
fairly,
Mr. Yukan, senior counsel for the petitioner, who has pointed out that despite the repeated orders passed by this court, including the order dated 12/6/2023, no affidavit has been filed till today. Mr. V. Majumdar, learned senior counsel, hosted by Ms. M. Bhattacharjee, is present on behalf of respondent number 4 and submits that affidavit will be filed shortly.
my lord,
However, it appears that
within a week's time, we can file.
despite
Lordship may record
time
my
granted
submission.
by this court, no affidavit has been filed till today clarifying the matter. Therefore, this is a fit case where personal appearance of the respondent number 4 is called for. However, in view of the request made at the above. This matter is posted again as a fixed item on 20th of
Tuesday, madam. Well, we'll file the affidavit on Monday. Madam,
whatever, but we'll go by whatever the order of the
Well, we'll
court is.
file the affidavit.
Much of it.
I'm assuring the sound report, but we'll file the affidavit. Don't want this.
Oh, sorry. Lordship, last occasion, Lordship has heard the matter and it is disciplinary proceeding was initiated against the petitioner. Ultimately, Lordship, 2 increment was withheld. Order was punishment was 2 increment was withheld. We have filed appeal was dismissed. Thereafter, I have filed the petition challenging the departmental proceeding. On the ground, Lordship, the inquiry officer's report has stated that inquiry has not been proved. Thereafter, imposed the penalty of withholding of 2 increment. Now, Lordship, I prayed for opening the Lordship, the DPC, which was kept under seal cover. That hearing was taken place. They have said there is an office memorandum by which when the 2 increment is withheld, the promotion can be withheld till it is covered. We have challenged this notification by this petition, Lordship, on the ground that as per some disciplinary appeal rules, punishment is withholding of increment or punishment or promotion. That is why we have.
So pleadings are complete.
No, Lordship. Lordship, we need some time to file our affidavit, Lordship.
Only thing is, Lordship, prima facie it is established that there cannot be withholding of increment or promotion. So we want seal cover.
We'll give
Opening
them
of the
last chance to file affidavit and then we'll take up the matter. This has to be disposed of finally.
Before vacation, Lordship, I want, Lordship, only the opening of the seal cover, Lordship. Not beyond that, Lordship. Lordship will dispose the matter regarding departmental proceeding, whether it is prima facie established or not, that will be decided by Lordship after going through the affidavit. But prima facie it is from the record itself, from the rule itself, the notification which has been, they have claimed that on the basis of notification, they are not opening the seal cover regarding this promotion of the petitioner to the next higher rank. This seal cover procedure should be open.
All right, we'll fix the matter on
Before vacation, Lordship.
18th of July and giving them chance to file affidavit. Last date will be 30th of June for them to file affidavit. You file your rejoinder in the meantime and then we'll take it up. The affidavit will be necessary.
Yes, okay. Lordship. Only thing is, Lordship, for the first writ petition, I am not claiming that it should be quashed or it should be disposed of. For second writ petition, I have been recommended by the DPC as per my knowledge since 2017. Because of the disciplinary proceeding, my decision was kept under seal cover. Now my all juniors have been promoted. I'm a senior number 1, Lordship. That now, Lordship, they have not opened the seal cover only on the ground because of the notification issued earlier in 87. That notification cannot, Lordship, because it conflicts the rules.
So do you have a prayer for interim relief?
Lordship.
Which writ petition?
No. Second writ petition, we have challenged only that. First writ petition, we have prayed for interim relief. We have prayed, Lordship.
No, in the writ petition where you want the seal cover to be open, that is which writ petition? WPC number?
Lordship.
Two 2125, Lordship.
Lordship, 2125, page 21, Lordship.
So is there a prayer? No further promotion to be given without.
Junior, Lordship has already protected that. Lordship. Only my prayer, Lordship, this.
We'll pass that order, Mr. Goswami, that's all. Heard Mr. S.K. Goswami, learned counsel for the writ petitioner, appearing in both these writ petitions. Also heard Mr.
C. Sharma.
C. Sharma, learned
For water
counsel
resource.
for the Water Resources Department, Assam, who submits that 3 weeks further time is required to file affidavit. Mr. Who, you are appearing for whom?
I'm from the petition numbers are 2240. I'm appearing for my response.
Mr. S.K. Mehdi appears for respond number 5 in item number 2240 of 2023, writ petition number. Mr. R. Dhar,
42. Item number 42. Response number 4.
appears for respond number 4 in item 42. Since urgency has been expressed in the matter by Mr. Goswami, both these writ petitions are directed to be posted as fixed items on 18th of July 2023. The department is granted time till 30th of June 2023 to file affidavit. The petitioner may file rejoined thereafter, if so required. It is made clear that no further time will be granted for filing affidavit in this case. Yes, the matter accordingly, yes.
Obliged.
May I please, Lordship,
Yes.
on 2nd June, Lordship, this court directed to file affidavit. Lordship, affidavit has been filed, Lordship. The fresh proposal has been sent to Director of Social Welfare to the Principal Secretary of the Government of Assam, Lordship. That instruction I have not received, Lordship.
You have received.
My lord, this is a very simple case, my lord. The case is that they are qualified for receiving the benefit as has been granted by the finance department. But because of one point that the officer, the director did not send the proposal in due time. And therefore, their prayer for getting the benefit is rejected. After rejection, my lord, they are not in the role of employee. And there is attempt.
Who is
to remove
appearing in the finance department? You are appearing in this case?
Yes.
Yes. Fresh proposal has been sent.
And it is agreed by law.
Let me place the status of the proposal.
There is no controversy, my lord, that they are working, they are qualified to get it.
Counsel for the petitioners also had Mr. A. Chakravarti, learned counsel, who submits that the department has sent a fresh proposal for
14 February 2023, Lordship.
on 14/2/2023. For what is the proposal for?
Proposal for, Lordship, for granting minimum scale
For
pay
granting
of the
minimum
employees, Lordship.
scale to the petitioners and a response from the finance department is awaited. Mr. B. Gogoi, learned standing counsel, finance department, appearing for the respondent number 3, prays for time till 27th of June 2023 to produce a status report in the matter. Prayer allowed, let this matter be listed again on 27/6/2023 by showing the name of Mr. B. Gogoi, learned SC Finance in the cause list. Let him produce a status report.
Lordship.
Then we'll pass an order. Yes.
Obliged.
Some orders are good.
Vacation, let's see. Because today we have five.
I'm on the item number 46, I have also filed an.
Your item number
42.
46. You have also filed IA. Let it be. Learned counsel for the petitioners appearing in items 44, 45, and 46. Case number, submit that they have filed separate interlocutory applications in all these petitions today only, which is not on record. As such, a request has been made to list the IAs along with these contempt cases after the summer vacation. The prayer is not opposed by Mr. S.K. Talukdar, understanding counsel, learned counsel appearing for the respondents. In view of the above, registry to list the IAs along with the contempt cases again after the summer vacation.
If already filed, copy has not been served to me yet, madam.
In the meantime, copies of the IAs be furnished to the learned counsel for the respondents.
I'm appearing in item 43.
Yeah, I think if
Item 43.
अच्छा तो चले 43, 44, 45, 46. Sorry, I can look at it. 46, 47, 47 also, Mr. Bhagavati. You are appearing in 47, item 47.
47 also, Lordship.
IA has been filed.
No, not required, Lordship.
अच्छा. तो चले 43, 44, 45, 46. Order to list along with the IAs as well as item 47 after. Yes, item 48.
Lordship. Lordship, as per last order, Lordship. This contempt was directed to file the affidavit. And in compliance of the last order, Lordship, just before few minutes, Lordship, I have received a copy of their reply, Lordship. Lordship, if Lordship permits me to read the relevant paragraph.
They filed affidavit.
Filed affidavit, but they are trying to defend their case, Lordship, not to comply with the order, Lordship.
No, who is the counsel for the respondents?
Mr. Gopal was there, I have Gopal, Lordship.
Sorry?
PN Goswami probably, Lordship, he is the.
You have received it just now?
Yes, Lordship, after few minutes.
After no, before few minutes.
Sorry.
Yes. So let it be listed along with the affidavit. I heard Mr. J. Kalita, learned counsel appearing for the petitioner. None is appeared for the respondent, although the name of the counsel is shown in the cause list. Mr. R. Gogoi, learned counsel, has appeared for the respondent and submits that
You file it.
affidavit of opposition
Filed it,
has been
Lordship.
filed today
Yes, Lordship.
morning.
We have surveyed a copy.
Today, by serving copy to the petitioner's counsel. But this said, affidavit is not available on record. Registry will therefore list this matter again after 2 weeks by tagging the affidavit with the record of this case.
I'll reply.
The petitioner may file rejoinder in the meantime, if so required.
Okay, sure.
Yes.
Three pieces,
We have
Lordship.
preferred a review application and it was posted last week, my lord, on 13/6/2023. The other side has also appeared. Other side has appeared, there is a petitioner of the contempt, my lord, contempt petition, he has also appeared.
No stay order regarding the maintainability. We have sought for time, your Lordship, it was granted.
Yes, so let
Lordship,
it be after vacation, my
No,
lord.
Lordship, we have urgency. Lordship will remember this case. Order of regularization came in my favor. Benefit was given to somebody else, your Lordship. It's a grateful worker, your master worker, your Lordship. Workers. I'm assailing contempt. They, as against the order 27/2021 at page 36, your Lordship.
What is this order about? This is review.
Review, my lord.
No, Ms. Bhuya, you see, you may have urgency, but this court is left with no option but to take this contempt case along with the review petition. That is the only recourse that is now possible.
Lordship. will
Because we
kindly-
cannot say that let the review be decided, in the meantime you comply.
Lordship, there are
The
two-
moment the order is complied, the review becomes infructuous. That's the problem.
Lordship.
You had to get an order of dismissal of the review. The order you are seeking,
Lordship, if that
the
review.
order you are seeking
Yes.
cannot be passed in the IF.
No, they have not preferred review against the order against whom I have filed contempt application. They have preferred review of the earlier writ petition, order of earlier writ petition, my lord. Second writ petition at page 36. Your Lordship, can we have a look?
My lord, two
They are
orders.
assailing review
But
of the
this
earlier
petition,
order. Let me
the
complete, let me submit.
Order was for regularization. Second is, my lord, for non-retention, my lord, of that particular post, the regularization order could not be complied. Second writ petition, my lord. So first writ petition is the main order, my lord, which is a consequence of the, my lord, second writ petition, my lord. In the first, we have preferred the review, my lord. If the review or the regulation order goes, second writ petition automatically.
No, automatically, no. The
Yes.
court order does not
No,
evaporate.
not automatically, my lord. That also we have prepared a review, my lord. But before that, my lord, we'll have to get a review in this particular regulation order, my lord.
No, there is no review against the order which is seeking compliance. Therefore, what option do we have?
No, my lord, since my lord, Lordship may kindly consider, my lord, page 18 for a moment, my lord. For a moment, my lord. By this order, direction was given that the petitioner should be regularized. Now, my lord, thereafter the
There was a
irrigation,
mistake. That is why the petitioner was not regularized.
yes,
Somebody else by his name
yes,
was.
Lordship, is there.
regularized.
Yes, aware of the facts.
So-
Now, my lord, in the second writ petition, the district authorities, my lord, of the, my lord, irrigation department, they, my lord, hurriedly regularized the petitioner. But she was not getting the salary and all, regularization benefit. Then it came to light that there is no, my lord, retention of that particular post and concurrence of the finance department. So, my lord, for not having that concurrence and all, my lord, since the matter was pending, the petitioner again approached the honorable court. Then honorable court said that you do the needful in the second order. Now, my lord, since we are preparing the review in the first order, which is a consequential, my lord, consequence of the, my lord, ultimately the second writ petition. It both are connected, my lord. We cannot prefer a review in the second against the second writ petition order, my lord, without, my lord, having a review of the first.
But once you have regularized the petitioner, how can you withdraw from? it?
Regularized by the, my lord, irrigation department without having approval from the finance department.
retention-
Regularized by the executive engineer lordship without the concurrence of the higher authority lordship, without the approval of the higher authority.
Not even
Oh,
the-
you throw him out of service, otherwise you will have to comply with this order.
Yes, yes.
Have you taken any action against the executive engineer?
My lord, it's their part, my lord.
Lordship, that instruction I have to take, lord.
No, sorry, we can't. These things can't. be
Lordship,
accepted.
because
Because,
of
Lordship-
their fault, I'm suffering, your lordship. The order of regulation came in my favor, just in between the Chandra part is not there. My name is Bhuvan Chandra Das. The person having same name was given the benefit, your lord, as long as he's getting, enjoying the benefit.
So let it be after 2 weeks, my lord. If the
Lordship, they are
review is
taking time
dismissed, my
on
lord, we will have no other option.
once
but to
after the
comply.
another, your lordship.
Take down, heard Ms. B. Bhuya, learned senior counsel appearing for the petitioner, also heard Mr. B. Gogoi, learned counsel appearing for the respondent number.
My lord, here I appear for phone number 2.
Respondent number, you don't know.
No, my lord, 3,
Respondent number 3,
my lord.
Mr. N.
2 and 4, lordship.
Learned counsel is present on behalf of respondent numbers 2, 3, and 4. This contempt case has been referred alleging willful disobedience of the order dated 27/10/2021, passed by the learned single judge in WPC number 5643 of 2021. Whereby a direction was issued. Where is that order of the single judge?
Page
Page
38, my lord.
Page 30.
There are 8.
Whereby a direction was issued by the learned single judge. To do the needful.
Seven and 8.
For release of consequential financial benefits to the petitioner after the order of retention is issued within a time frame provided in the order. The order of this court has not been complied with on the ground that a review of petition is pending before the learned single judge. However, after verification of the materials on record, it has transpired that there is no review petition referred against the order dated
27/10/2021.
27/10/2021, passed by the learned single judge in WPC number 5643 of 2021. First up, although Mr. Gogoi submits that review petition has been preferred against the original order
Yes, my lord.
dated 22/2/2019, passed in WPC number 4381 of 2013, which had recognized the right of the petitioner of being regularized in service. There was no need to prefer a review petition against the
No, we are
subsequent.
preparing, my lord. It's not that we will not be filing, but without.
No
having-
review petition has been preferred against the subsequent order. However, such argument of the learned counsel for the respondent cannot be accepted so as to stall further proceeding in this review petition. First up, having regard to the facts and circumstances of the case in its entirety, the respondents are granted time till 19/7/2023 to comply with the order. If the order of this court is not complied within the next date fixed, who are the respondents will remain personally present. Respondent number so and so.
Finance Department, Commission Secretary, your lordship.
Who are the respondents? Can you please point out?
Lordship, 3, respond number 3.
But 3 is not in
2,
finance
3,
department now.
4.
my lord. He is not there in the finance department.
Who's in the finance department now?
Now, my lord,
Which is the respondent in the finance department?
my lord, Manish Thakur is presently not there.
Who is there?
Jayan Narleka.
Is there a party here?
No, sorry. That we have already informed to the.
No,
court,
no,
my lord, sorry.
they have never been informed. Your lordship may kindly see the earlier proceedings. Never been informed that they have been transferred. Otherwise, I would have made them as
I
party
have made a
respondent.
categorical
No,
statement in this
no,
regard long
no,
back.
your lordship. Your lordship may kindly have a
No,
look.
Ms. Bhuya,
My lord.
see,
Their client, my lord, they
this
are-
is not okay. We have to go by the edict of law. If the respondents are not parties to the proceeding, we will not proceed unless they are made parties.
Lordship,
Whether
they-
you are aware,
they
you are not aware, this is
They have
another.
to inform before this honorable court.
Yes, so they are
did
not parties.
inform.
My lord, they are not parties.
Granting time till 19/7/2023 to comply with the court's order. Since Mr. Gogoi submits that
They are the representative of the authority, your lordship, finance
Respond
department.
respond number 3.
Lordship, respondent 1, 3 and 4 are not no longer in the service force.
Respond numbers 1,
They not particular post,
are
Lordship.
no longer holding the posts for posts which are responsible for implementation of the court's order. The petitioner is granted leave to file appropriate application for implementing the present incumbents in the office after demanding compliance with the compliance of the court's order. You have to follow this process. There is no other way.
They did not inform.
There is
They
no
are the
other-
representative of the department. They are to inform.
They
They
have
are
to
not
inform.
aware.
What to do? How can
Never
we
been
proceed?
informed. Your lordship may kindly see the earlier process. Never been
That's
informed.
correct, but what to do? You tell me what to do. What do we do now?
My lord, what to do?
I
Have
can
to wait.
understand you will
My
be,
lord.
there will be frustration, but what to do?
Lordship, I'm representing the petitioner.
We are what to
Unless
do?
they're changing their stand every now and then.
You can't get frustrated. You have to deal with
No,
the
your
matter.
lordship, I am answerable to my client also, my lord. This person
So-
is suffering.
So would you please submit what is the order you are seeking today?
Lordship, I'll leave it to your lordship. I'll file appropriate application. My client is suffering a lot because of their fault, my lord.
Is it
Yes, my lord.
personally related to you?
No. He's the
Why
person.
are
He's
you
suffering.
crying?
No, I'm not crying. I've become emotional because they are making false statement before this honorable court.
When I made my false statement.
That their clients have trespassed. All this, please, they should have taken before, my lord.
That's all right. This court was willing to direct personal appearance.
My lord.
But the fact of the matter is, these respondents, if you direct personal appearance, they will come and say that we
Yes.
cannot comply with the court's order because we are not in office.
Lordship, but during that particular period when the contempt was committed, they were very much there in the office.
So
So contempt
we'll proceed against them at that stage.
Lordship,
Today they cannot-
Lordship, I'll file appropriate application before the
What is
court
the
of law.
other
I have to abide by the rules of this honorable court.
What to do
Yes.
now? What is the
Lordship.
way out?
Lordship, nothing.
We can call them and shout at them, but they can't comply with the
Lordship.
court's order.
But the contempt proceeding, whenever it was violation, whoever was the official, they'll equally be responsible, my lord.
They will be
Because their
responsible,
names will not be deleted. There will be addition of the parties, name of the parties, my lord.
but they cannot comply with the court's order. You are saying they are the people who are in
No,
office.
they are equally responsible. Those persons who were at the relevant point of time was in the office,
Hmm.
they were equally responsible, my lord.
They are responsible.
Yes.
But today, to get the order
No,
complied,
I'll make them as a party respondent, whoever in the office is on today, as of
Hmm,
now,
hmm.
I will make them as party respondent. But the other respondents who were there in the office during the time when
That you are
yes,
right,
they're
that you are
equally
right.
responsible.
I was about to direct personal
Yes, yes.
appearance, but then what will be the
If
result?
they would have informed, my lord, they should not go by the dictates of the officers. They should be fair enough to the court. my
Mr.
lord.
Gogoi, what is this? Your people keep changing every 6 months and then contempt cases. Huh?
That's not in our hand, man.
You don't have any website, any portal where the
Yes, ma'am,
names
it is
of the
there, ma'am.
officers are
It is
there?
there, madam. In the finance department, its names are already reflected.
Which is the website?
By the finance department, government of Assam, if anybody searches in the Google, madam, they will find it, madam. Otherwise.
Yes, your
Now,
lord.
if
Then
the-
when we filed the contempt application, these officials were very much in office. And unless they informed this honorable court, they have got transferred. I would have no other alternative but to file petition for implementing
That you have a
themselves.
point.
Yes.
Definitely you have a point. This
have
amounts
been
to some
informed.
kind of a harassment for the
Yes,
petitioner.
my lord.
How many IAs will be filed? So we are not letting them off.
No. That part I understand,
You
madam.
know, just a technical requirement
Yes.
because the
So-
court
Yes, I'll
ultimately,
abide by my lord.
if the court ultimately passes a strict order, then these orders are challenged on these technical grounds.
Lordship.
And then everything gets obliterated.
Yes.
Therefore, she has to comply with it. But other than that, the
Yes,
court
ma'am.
is totally unhappy with the conduct.
Lordship.
I'm making it very clear. Very, very unhappy. You better figure out.
Lordship.
You are showing your might against a poor person.
No, not that, madam.
What is this? You are showing law, and this morning also I've observed all the legal issues are cropped up when grateful people are seeking remedy before the court. You are showing them law of regularization of service, temporary appointment, these, that. How are these people supposed to know? They are most vulnerable. They are working in situations where a little protest, they may be thrown out. And after 10, 15, 20 years, you take up technical plea. Law is technical, but it is not inhuman.
Lordship.
So Another day will be another day, Mr. Gogoi. Please tell
My-
it to your clients.
Yes.
We are not going to accept all this. What is there to review in this order? Review, you get a stay order. Otherwise, we are not concerned. The only reason today personal appearance has not been given
Officers are not.
is because these officers are not in office today.
That's
Otherwise, your submissions are rejected.
my-
No, even if you file a review petition, unless there is a halt of the order, we'll go ahead.
Lordship, I'm sorry, I could not control my
No,
emotions.
no, it's all right. We can understand these matters do generate frustration. But then this temporary frustration have to give way to
My
the
lord.
requirement of rule of law.
My lord.
We have to all go by that.
Lordship.
That you have to keep in mind. Yes.
Oblige.
With this application, I reviewed the order dated 27/3/2023, my lord. Yes, page 22, my lord. On the submission of the, my lord, earlier set of counsel, my lord, the IA has been, my lord, dismissed, stating that he has instruction to not press the matter. But if he is, my lord, earlier set of counsel, my lord, I am the present set of counsel, my lord. Kindly see, my lord, annexure A, page 12, my lord.
No, but your name is recorded.
Recorded, but my lord, that this honorable court, my lord, kindly see, my lord. The case for my
You
lord.
will issue notice, you file your objection.
Lordship, please, objection, Lordship, not.
You don't have any
But
objection.
what I would submit, Lordship, since an allegation is made against an earlier counsel, Lordship, at least he should have been made a party. Because that
Who is the earlier? Your name is recorded.
Recorded, but I am the, my lord, the applicant as IA, my lord. But he haphazardly made a submission that, my lord.
No, in the order.
Order, my lord.
Order dated 27/3/2023. Your name is recorded.
Recorded, my lord.
Then
But
you are making an allegation against yourself.
No, my lord, but prior to my submission, my lord, he stated that, my lord, he has an instruction to not press the matter. And on submission, my lord, the IA has been dismissed, my lord. But the learned earlier set of counsel, my lord, kindly see page 12.
Then
my lord.
you serve a copy on him and who is the earlier set of counsel?
My lord, Mr.
Heard
Malot,
Mr. K.R. Patgiri, learned counsel for the petitioner, also heard Mr. R.K. Dev Chaudhary, learned DSGO appearing for the respondent. In view of the projection made in this application, this IA cannot be taken up for disposal unless the earlier set of counsel represented by Mr.
Konak Sharma, my lord, senior counsel.
K. Sharma is heard in the matter. As such, let this review petition be listed again by reflecting the name of Mr. K. Sharma as the counsel for the writ petitioner in the cause list. A copy of the IA be served upon Mr. Sharma in the meantime.
My lord. Oblige.
May I please? My lord, the review petition, my lord, seeking, my lord, the modification of the order passed by the honorable court at page, my lord, 66. And my lord, property part, my lord, at page, my lord, 68. Third from my lord.
Yes.
Yes. Now, in the meantime, my lord, corrigendum, my lord, came, lordship will find at page 70.
What is the wrong in the order?
My lord,
a corrigendum, my lord. In the corrigendum, my lord, it is fixed, my lord, 30 years. But in the earlier notification, my lord, it was fixed, my lord, 35 years of, my lord, age.
You are
As-
29 years.
Yes, 29 years. That is, my lord, in the, my lord, order. But so far the, my lord, birth certificate is concerned, as per the birth certificate, she is 31 years, my lord. He is-
Birth certificate was not in the HSLC admit card will only be accepted.
Yes.
No
But
birth certificate.
a birth certificate was not considered.
No, that is not, that the law is not there.
Yes.
Then you have to go to division bench.
Yes.
Because the judgment of the division bench is there in this case.
Yes, my lord.
Only the admit card, HSLC admit card will be accepted. If that is there.
That is the issue, my lord, involved.
That issue cannot be changed because the single judge will be bound by the division bench order. I'm so sorry, I heard Mr. M. Mondal and a counsel for the petition.
And
Also
also,
heard-
one more thing, my lord.
Yes.
After, my lord, seeing this, my lord, situation, my lord, he has filed an appeal before the, my lord, appellate authority. That appeal is also pending.
He's under.
Maybe, but you are not eligible.
Yes, Lordship.
Yes.
You are not eligible. You get a verdict from the division bench that HSLC admit card can be ignored and birth certificate can be accepted, then the matter will be reheard.
Well,
Otherwise, how can this court do it? What you are asking for is contrary to the judgment of the division
yes.
bench.
But
Are you aware of the judgment?
no, my lord, I have heard, my lord. I will.
You have heard?
Yes.
You find out. You find out. I cannot, as a single judge, pass a verdict contrary to the judgment. And counsel for the petition also heard Mr. L. Doctor, that is standing counsel, Revenue Department, Assam, appearing for respondent number.
Number 2, in review petition, respondent number 2, Lordship.
Respondent number 2, Mr. C.S. Hazarika, and Government Advocate Information appeared for the remaining official respondents. First up. By filing the review petition, the writ petitioner is seeking review of the order dated 27/1/2023 passed by this court in WPC number 386/2023. According to Mr. Mondal, although the date of birth of the petitioner has been recorded as 02/09/2022, yet in his birth certificate. No, not 02. What is the birth certificate?
31/12/1993.
31/12/1993. Yet, as per the date recorded in his birth certificate, the age of the petitioner is different. Full stop. Therefore, a review has been sought of the order dated 27/1/2023, by means of which the writ petitioner was dismissed by holding that the petitioner was not eligible to apply for the post of Gav Pradhan under the advertisement notice dated 02/09/2022. It has already been held by the division bench of this court that when the HSLC admit card is available, the date of birth recorded therein will have primacy over other documents. Moreover, the birth certificate, is it on record? Birth certificate?
Yes, it is on record. My lord, page 14, Lordship will find.
Taking note of the date of birth recorded in the HSLC admit card, this court had dismissed the writ petition. Question. Under the circumstances, I do not find any justifiable ground to review the order dated so and so. As such, the review petition stands dismissed. It's prefer an appeal.
In this case, my friend is appearing for respondent number 1. I am for the remaining state.
1, I will remain.
Yes, writ petition.
Lordship, next
But
item, Lordship,
the-
similar order.
Writ petition, my lord,
52 and 53, Lordship,
Yes.
similar.
writ petition number, my lord, 2287.
52 and 53, yeah.
52 is the review petition,
And then-
53 is the writ petition.
petition,
Yes,
yes.
writ petition.
It was tagged.
Tag, Lordship.
So writ petition is disposed of already.
No, no,
No,
no.
but
no, no.
subsequently, writ petition
Subsequently, he
filed.
has filed for disposal of the appeal.
Yes.
Subsequently, he had filed for disposal of the appeal. So.
Disposal of the
it's not
appeal.
Appeal
an
pending,
eligible.
yeah, Lordship.
Challenging the, my lord, merit list.
You have been held to be not
Yes,
Yes.
eligible.
yes, Lordship.
We take down, had Mr. M. Mondal and counsel for the writ petition, also had Mr. S. Battal and SC Revenue Department
For respondent number?
appearing for respondent number 1 and Mr.
Yeah,
C.S.
that will come.
For the respondent numbers
3, 4, and 5.
3, 4 and 5. Full stop.
And 7, your lordship.
Huh?
7 also included.
3, 4 and 3, 4, 5 and 7. Full stop. This writ petition has been filed with a prayer to direct the respondents to appoint the petitioner as Gaubura, public Gau Pradhan of charge number 20, Jania Moja, under Bagbor Revenue Circle, Mandia. Full stop. However, by the judgment and order dated 27, what was the earlier judgment?
Yes. 27.
What is the review petition?
58 of 23.
Judgment and order dated
27/1/2023.
27/1/2023. Passed by this court in WPC number
386.
of 2023. It has already been held that the petitioner is not eligible to participate, was not eligible to participate in the selection process in terms of the advertisement notice dated 3/9/2022. Advertisement is 3/9 or 2/9? 2/9/2022. First stop. The review petition preferred by the petitioner against the order dated
Advertisement 3/9.
27/1/2023. Being review petition number 58/2023. Was also dismissed by this court by order dated 16/6/2023. As such, nothing survives for adjudication in this writ petition. The same was also accordingly closed.
My lord, advertisement dated 3/9.
Advertisement is 3/9.
Sorry.
Just now you said 2/9.
Sorry.
Yes.
3/9.
Deep
There will be a
locus.
change in the other review petition order also will be 3/9. Shall go with
Obliged.
that.
May I place also? My lord, this contemplation related to non-compliant honorable High Court order dated 8/9/2022, my lord.
Notice has not been issued.
No.
I heard Miss
Dishonorable.
Honorable and counsel for the petition. Notice 8 weeks.
In this case,
Yes.
also, my lord, notice may go. First time.
Mr. Das, notice 8 weeks. Steps. Alleging willful.
Your lordship, in this case also notice not issued.
Mr. AMS Majumdar, 8 weeks.
Obliged.
In this case, we want to include me respondent, seek the new incumbent chief secretary. Pawan Kotak. Last time Vishnu Pur was, he retired. And the upcoming.
This IA has been filed with the prayer to implead the incumbent chief secretary, government of Assam, as a party respondent to the connected contempt case. Have you demanded compliance?
Yes, and we have filed a representation, fresh representation.
No. Have you demanded compliance of the order from him? The
Yes.
rule of impleadment is you have to first demand compliance.
Hmm.
You have not done it, so do it and then come back again. However, it appears that the applicant has.
Last time, regarding the erstwhile secretary also.
Yes, not yet demanded compliance of the order of this court from the incumbent chief justice. As such, by granting liberty to the applicant to approach this court by filing proper application after he has demanded compliance of the order of this court from the chief secretary. This highest and disposal. You first demand and then come. Yes. Mr. Goswami, you have been waiting. I'm not starting a part 2 hearing matter.
No problem. I just, I wasn't sure, therefore I was waiting. No issues. Next week we'll take a
You can
chance.
try on Monday.
My lords.
Mr. Das, Monday.
Same matter, madam. Mr. Das is my opponent.
That's right. This is not the right time on a Friday evening to start a hearing. And besides that, some works are lined up also. So we'll take it up on